go ahead and start. She'll be with us very soon.
And
Okay.
Mary is on the public side, so you can just promote her.
Perfect.
Great.
There we go. All right, we now have a quorum and we'll begin the meeting. This meeting is being recorded. With the permission of the chair, I will start with the roll call.
Please.
Okay, Justice Tucker,
Yes.
Mary Baldwin,
Here.
Rebecca Sandifer,
Present.
Marta Altenbrock,
Here.
Andrea Ruda, Judge Wendy Chang,
Here.
David Engstrom.
Here.
Bridget Grammy, Tom Green, Dan Grunfeld,
Here.
Eric Helland,
Here.
Kathy Huang, Micah Star Liberty,
Here.
John Lund,
Here.
Ruby Marquez, Kevin Moore,
Here.
Kristen Passmore, and Toby Rothschild.
Here.
Thank you.
I'm also here.
There's
Okay, sorry.
two more.
Oh, sorry. I have to keep scrolling down. Jim Sandman, sorry.
Here.
And Patricia Scutiera.
Yes, here.
Thank you. Sorry. It's a very long list. All right, thank you.
All right. Thank you all. Let's go forward with public comment. If there have been any requests, I would ask any members of the public who would want to address the group to limit your comments to 2 minutes.
Okay, the first person I will call on is Tom Gordon.
Thank you. My name is Tom Gordon. I'm the Executive Director of Responsive Law. We're a national nonprofit organization working to help consumers of legal services have better access to the legal system. I'd like to comment on the scope of the sandbox proposal before the working group. We believe that the scope should more closely follow the example of Utah, which you're hearing about later today, that the requirement that the potential benefits of increased access to legal services are substantially outweigh any identifiable harm is too broad. Substantially outweighing is the wrong standard here. There shouldn't be such a high burden on sandbox applicants to prove benefits of services that don't yet exist. Rather, you should look at whether there is a substantial risk of consumer harm and weigh that against the harm to consumers of having no viable options for legal help, which is the current status quo. Furthermore, limiting the sandbox to unserved and underserved populations would be a serious mistake. First, the main hypothesis being tested here is that we don't actually need Rule 5.4 to protect lawyers' professional judgment. And there's no reason we should be more hesitant to test this hypothesis with higher income individuals and mid-sized to larger businesses than we are with the unserved and underserved. Furthermore, this proposal is unnecessary. Almost every person in this country is underserved. As many of you can attest, most lawyers can't afford their own services. So any service that is innovative will be helping anybody they help would be unserved or underserved almost by definition. But there is a fear that this would create a mandate to have a pro bono or a low bono component that hampers the development of alternatives. Every new business process is going to become cheaper over time, but it can't get there if it's got a regulatory mandate to help the poorest at the outset. And we won't be able to tell where the greatest innovations will come from until they're operating. If you look at, for example, the auto industry, the assembly line didn't make cars instantly accessible, but over decades, it did make cars going from the point of accessible to the top 15% of incomes to today, where we're at over 90% of people. So I urge you to not stop the next great innovation, wherever it may come from, before consumers have a chance to benefit from it. Thank you.
Thank you, Mr. Gordon.
Next, we have Stephanie Bond.
Hello, thank you. I'm Stephanie Bond. I've commented a lot over the last weeks and months, and I'd like to echo and support the comments from Tom Gordon and the written comments that were submitted from Isles that I've been reading. And I'd like to say this. I'm from a judicial assistant background in Canada, so I'm watching this with great interest, and I'm looking to see a real sandbox where they're really going to test new things, and focusing on the underserved and saying it has to focus on them misses the point. It's coming up with innovations that people of modest means can afford. And the way to do that is to open the gates wide. And, you know, if you want to say, okay, disbarred lawyers, yes, I agree. You don't want them coming in, but open it wide and see what comes in. Don't try to strangle it and regulate it before anything's happened, because you won't get innovation. You won't get new products that are capable of doing what you want them to do. If you want to get access to justice, you have to open it up to innovation. Thank you.
All right, thank you, Ms. Bond.
That's the only people we have, so we can continue with the rest of the agenda.
Okay, thank you. Well, next on the agenda is announcements. Let me make a couple before I turn it over to staff for the staff report. First of all, as many of you know, because you're involved in them, we've had some productive subcommittee meetings since we gathered last as an entire working group. And I want to announce the great news that Micah Star Liberty is joining the SCOPE subgroup and will participate going forward with that group. And also the news that sadly we lost Reem Alor, but we, as you might have heard in the roll call, we have appointed Andrew Arruda to replace her. He will be joining the subgroup, even though he was just appointed early this week. He will be joining us today, and we'll introduce him properly when he's able to join us, which should be middle of the day-ish. But it's wonderful to have him. Some of you know him from his involvement in ADLS. He will be joining the SAGE subgroup where Reem had been serving. The other announcement I want to make is going forward. We've been thinking about a project that you'll hear more about either at or just before the June meeting when we next get together. But I wanted to take a moment to explain it here now so that you know what's coming. You may remember from when we first discussed very briefly the work plan of this group and the charge of this group, that in addition to fleshing out a proposal for a sandbox, we have been charged with looking at a collection of specific changes, proposals for changes to the rules of professional responsibility. We mostly are planning to do that work next spring as a group. But in order to not wait entirely until next spring to have the group focus on what some of those issues are, we would like to bring forward to our September meeting an introduction to the issues of, separate and apart from the sandbox, what proposals might this group bring to the State Bar for amending these I think it's 4 different rules of professional responsibility. So we are going to ask at the June meeting or just before the June meeting that members of this work group who are interested in this subject volunteer for one of the specific rules that we're going to be looking at next spring to work with a partner. We'll put you in pairs to study and then present at our September meeting what are the proposals that either have been looked at in ADLS or looked at in other fora that this group might want to consider, or what are the issues that this group might want to consider about making proposed changes to any of these specific rules of professional conduct that we've been charged with taking a look at. So I'm letting you know this now so that you can start to think about whether you'd like to volunteer to be one of the people on one of the 4 different rules we're going to be looking at. And we'll be soliciting your input at or just before the June meeting so that you have the summer to work on the project to present in September with your partner on an introduction to the question of whether we should, for example, propose a revised Rule 5.7 along the lines that ADLS suggested, just to take one of the 4 different rules that we will be looking at next spring. So those are the announcements I wanted to make. Randy, do you have a staff report?
Only two small bits. One is just a reminder that in connection with your work on the working group, please remember if you're sending emails to copy the ctjg@calbar.ca.gov. That's always helpful. And the other thing is nice segue from the discussion of the rules. I reported last month or the last meeting that the court issued its order on February 18th approving the rules recommended by ADLS and adopted by the board. Those were the competency in technology addition to Rule 1.1 and the expanded fee sharing under 5.4. Those became operative on March 22nd. The State Bar website has been updated. And so much like that, the ADLS good work, you know, a few years from now, we might have the rules from this body take effect. So looking forward to that. But that's all I have.
Super, thank you. So the next item on our agenda, if someone is prepared to make a motion with regard to the February meeting action, what's it called? Open session action summary, also known as the minutes from the February 19, 2021 meeting. Is there a motion to approve them? Or to amend them?
So moved.
Toby, can I get a second, please?
Second.
Thank you, Mary. All right.
Is it,
I
unless
would
there's any need for discussion, let's poll the members in a vote.
Okay, Marta Alkenbrock,
Approve.
Andrew Ruda, Mary Baldwin,
Approve.
Judge Wendy Chang, David Engstrom,
Approve.
Bridget Grammy, Tom Green,
Approve.
Dan Grunfeld,
Approve.
Eric Helland,
Approve.
Kathy Huang, Micah Liberty,
Approve.
John Lund,
Approve.
Ruby Marquez, Kevin Moore,
Approve.
Crispin Passmore, Toby Rothschild,
Approve.
Rebecca Sandifer,
Approve.
Jim Stanman,
Approve.
Patricia Gutierrez.
Approve.
Thank you.
All right.
Justice Tucker, I would note that Micah has had her hand raised. I wasn't sure if that was intentional or accidental.
It appears to have been accidental because it's no longer raised. But yeah, Ms. Liberty, go ahead.
Sorry, I just took it down as soon as she called on me. This is just a housekeeping request. I'm wondering if everyone can edit their names. It's so different to try to get to know people, especially this number of people on Zoom. If we were in one of the State Bar conference rooms, we'd have those little plaques and we'd be able to chat with each other over coffee breaks. And I think it would be really helpful for me if I knew who was a State Bar employee, who and what people's full names were. Can we do that?
Let's take a moment to do that. The way to do that, in the upper right-hand corner, if you hover over your own picture, there's 3 little dots. You'll see an option to rename yourself.
Or if you want, and you don't want to be distracting, I can do it while we continue the meeting.
All right, so anybody who wants to rename themselves can do that, and otherwise you will be renamed.
Yeah, if you'd like to do it yourselves, go ahead. Otherwise, I'll do it for you during the meeting.
All right, thank you. Well, with that, I think we can go forward now with the business of the meeting. And we begin today with presentation from the co-chairs of the SAGE committee on the report of their committee, which you all should have received in your meeting materials. So to the co-chairs of that committee, take it away.
Okay, thanks, Justice Tucker. And we don't have this as tightly choreographed as sometimes we do, right, John? But we have the advantage of a very detailed report from our 2 members of our committee who've been spearheading the close review of possible, call them governance structure models, very specific. How are we going to set this sandbox up and who is going to regulate it? And that's what we've been looking at, and we've we had a pretty good discussion at our last meeting, and the different sort of options that we discussed are set forth in this memo. And I think what we would like to do, and John, since we really haven't discussed this in any detail, I think, is walk through these models and discuss them and get people's input. And then maybe at the end of the day, end of the session, see if we have a consensus about, which of the models the group is, believes are most viable. And then if you read our report, you understand that we think an important next step is to have some legal work done to advise us as to the viability of any of these options. But John or Dan Grunfeld, as one of the authors of this, do you want to say anything or walk us through?
Well, I guess if it's all right, Dan and Mary, maybe I could just briefly walk folks through these options. I think the memo is really a good, thorough summation. I'd like to second the thanks to Bridget and Dan for putting that together. But substantively, here's where our SAGE committee sort of came down. If you look under the section called possible options, the preferred options of the committee would be the ones found under subsection A. And the essential feature of that arrangement would be that the entity is under the supervision of the Supreme Court, with critically a direct report to the Supreme Court. Now, we did kind of look at two different approaches for that sort of structure. The one would be that the sandbox is essentially its own governmental entity. And I'm not sure who coined this phrase. I think it might have been Justice Tucker, but then she backpedaled a bit. Is this like a sister entity to the bar, in the sense that at least in the sense that it's independent of the bar and it's directly reporting to the court? That's sort of this option one. And you can see the list of pros and cons there, I think are pretty straightforward. But, this element of the entity being somewhat independent of the bar, I think is potentially important both to the public and to lawyers and to providers who might come into the sandbox. The second structure, A2, we call it, is that instead of being a separate governmental entity, the regulator is somehow an office of the court and or judicial council, which is more like what we're doing in Utah. There are, as to both of these, there's sort of still some nuts and bolts issues to sort through in terms of what structure works and how the money would flow and that sort of thing. But that's the other sort of basic approach we had, where this is an entity under the auspices of the court with a direct report to the court. And then we have continued to list further down in the memo some other approaches, B and C in particular. We did, I think, rule out a couple of options, but wanted to leave B and C here for the entire committee to consider. B is this idea that it's a separate 501c3, which ultimately somehow is delegated the authority to regulate these services, with, of course, ultimate authority retained by the Supreme Court. But the idea is that one potential benefit of that is that there's a straightforward approach to create a 501c3, and it may create a somewhat different funding environment for the entity, the sandbox entity. And I think this is something that Dan contributed, this element of using that 501c3 as a member model, meaning that the board of that 501c3 could have representation from people like entities like the Supreme Court, the State Bar, and otherwise. And I'm sorry if I'm rushing through this, but I think the memo is thorough, and hopefully this will at least frame it up for some questions. The final option would be that this is an entity underneath the State Bar, operated by the State Bar, still with separate leadership and still reporting directly to the Supreme Court. But I guess the concept there is more that there's efficiencies if the same HR and IT and sort of structural, back office, if you will, aspects of the sandbox entity are shared with the bar. Of course, there's questions about the perception that creates and how that fits with the prosecutorial aspect of what the bar does. I think we got ourselves comfortable that any sort of antitrust concerns, well, there's still antitrust concerns, but they're largely resolved if we have a majority of the controlling board of that bar, which is non-lawyer. So I think I guess we left D on as well, which is that the entity is actually a part of the bar, not just sharing resources with the bar, but an entity reporting to the bar's leadership as opposed to the court's leadership. And then lastly, this idea that it be created as an office of the executive branch. I'm going through those quickly because I think especially D and E are ones that I think it's fair to say there was not a lot of support for among the subcommittee. And Dan, I don't know, would you like to take a shot at laying out the issues we think would still maybe need to be researched and analyzed around these various approaches?
Let me do that. Let me also add the following. I think that in toto, the subcommittee is recommending that we go with, for now, with option A1 and A2 because those options checks the most boxes. And the boxes that we're looking at is a measure of independence, two, the sense that at the end of the day, this is fundamentally a regulatory function, which is most appropriate to a government body as opposed to a non-government body like a nonprofit, because it further addresses either A1 or A2 state actor immunity in terms of providing at protection.
0, 1, 3, 1, 9, 6, 3, 3.
So again, there is no perfect model, but of the things we're trying to accomplish and the goals that we have been put forward by our mission, and because funding is going to be an issue under each model, but this model, we believe, based on what we know now, stands the best chance of getting one funder to take care of the life of the sandbox, may be supplemented by other funding. That's the recommendation to go forward with A1, A2. Let me just supplement a little what was just said. We're leaving options B and C in there because at the end of the day, as we do more research, and I'll get back to that in a second, there may be elements of that model that could be incorporated into either A1 or A2. The reason that D and E, at least at this point, being put aside is because there's both issues with perceptions and reality of ability to do the work, perhaps. And with respect to E, there's constitutional issues that are very challenging in terms of separation of powers, and whether that by itself would delay the process to an unacceptable level. So that's the sense and the rationales for going forward with the recommendation. In terms of what John alluded to, there is an express recommendation that we get outside pro bono assistance to help with this that will work with the State Bar General Counsel Office. The reason for that is that some of these issues may be, they undoubtedly be complex, may be cutting edge. And at this point, we don't know what we don't know. So the notion of finding one or two law firms that have great expertise in California law, in the confluence of corporate governance, state regulatory practice, administrative law, and constitutional issue can only help the process. And our sense is that while there's a relatively small number of law firms who would be able to do this work, they are highly likely to be interested in helping the committee move this important process forward. Let me stop there and ask if there are any questions or comments.
Are there any questions for Mr. Grunfeld or for the SAGE committee more generally? Okay, then let's open it up to a larger question, which is, are there any comments on the proposal and the recommendation that the SAGE committee is making? I note that we usually privilege anyone who's made a written comment ahead of time, and I believe the only written comment ahead of time on the SAGE report came from Crispin Passmore, who emphasized the importance of independence from the state bar, but he's not able to be with us today. So I'm going to open it up to everybody who is with us today who wishes to comment on the SAGE report. Okay, Tom Green and Mike, and then after that, Micah Liberty.
So just, this may be a question that one asks later, but it seems to me form should follow function. And did you guys discuss what this group should do? I mean, are they going to meet quarterly? They're going to need a staff, presumably. I mean, is there some sense about what this would look like? I mean, what I read here is where we put this thing in this black box in the governmental structure of California, and A1 and A2 certainly work for me. But what do you have a sense of what this group is going to look like and what financial requirements they're going to have?
So our task, let me see if I can jump in, Justice. The task at this point was to look at this at the, let's say, 300-foot level. There are some significant issues that the answers to which we don't know at this point, which will help guide and answer your excellent questions. The primary one is how much money this entity will have at its disposal and where it will come from. If it is, and I'm merely making up figures here for the purposes of making my point, if we get $500,000 as opposed to $5 million, to say nothing of $15 million, what this would look like, how it will be staffed, and things of that nature would dramatically change. And there are other considerations as well, including the Supreme Court has urged us to continue exploring all possibilities, do as much research, and put them in a position to make as educated a decision in the best furtherance of that institution and their function as society. We're not there yet. We don't have that enough information. And that's part of the reasons that we're recommending the pro bono assistance, because the angles of this, when you get into the weeds, that may actually have a great impact. So we considered it, but we simply don't have enough information at this point to answer this question. We believe this sets up the framework to be able to do so. Does that answer your question?
Yeah, no, that's very helpful, Dan. Thank you.
Tom, if I could just add to your question, just so you know, the other piece we were supposed to try to cover before this meeting, but we're not able to get to, was the question of makeup of the board of this entity and some other pieces. But I think as a working understanding, this is the office that would seek sandbox applicants, participants, evaluate them, determine whether they should or shouldn't be licensed under what, terms and conditions, probably interface with the court about that piece of it, and, report to the court around what's going on with the project, and or whoever has decided to be the overseer of it. And then ultimately monitor those entities when they're in the sandbox, do the whatever data collection requirements are placed in it. That whole process, I think it's fair to say, we're assuming there would be a board that would oversee that, which would have some, expertise from various areas, and then indeed a staff. But Dan's exactly right as to how much staff and how much it costs. We haven't delved into those details.
And those are things we might have some preliminary discussions on today, and that the SAGE committee will certainly come back to us with more information on. Ms. Liberty.
Thank you. I have another process question. So help me understand what happens next. We come up, we pick a structure or two, and then we approach the Supreme Court, the Judicial Council, or the legislature to find out if they're interested, if they agree. I'm just not sure what the steps are.
That's a good question, and let me try and answer to it. I believe that the project we're undertaking is sufficiently innovative and far-reaching, if we do indeed recommend a sandbox, that it's going to require both the approval of the legislature and of the Supreme Court before it goes forward. That's of course, originally we report to the state bar. The state bar, if they like our recommendations, will, I'm sure, interface with those organizations before those organizations would have to decide whether or not they support what we're doing and want to pass it into law in the case of the legislature to stand, to accept our recommendation and stand up a sandbox of the sort we've asked for. So I think as we think about our sandbox, we should think that it is something that ultimately the legislature will be creating or not. But in terms of immediate next steps, I think I would hope that one of the things that will come out of our discussion right now is some definition for the charge for the pro bono lawyers who will give us advice. We're not going to ask the pro bono lawyers to think about 5 different models and write us a report. We're going to say, this is what we're interested in. These are the issues we already know about, but we don't know what we don't know, as one of you just said. So please give us advice as to whether or not this makes sense in California constitutional structure. And to the extent that it raises issues, please comment on how some of our other suggestions might resolve those, or how we might resolve them. That's a first stab at an answer. Would anybody like to improve on it or refine it?
And I have a follow-up too. So I know we have some folks from the Supreme Court who are participating. Do we have anyone from the Assembly or the State Senate on our committee or that we're consulting with?
So the answer to that is that both houses of the legislature were asked to appoint members of our committee. The State Senate has not done so. The State Assembly has appointed Ruby Marquez, who is a member of our committee. We all look forward to meeting her when she comes to a meeting, but I don't believe she has yet. So our liaison relationship with the Assembly is and the Senate is still in the early stages. I feel fairly certain as we get further along in this process and we have more to say, that we will also have a more effective liaison relationship with the Assembly and State Senate, because obviously they're both going to be important for the ultimate success of our venture. Again, any additional commentary in response to Ms. Liberty's question?
So Justice Tucker, I would just note that the State Bar is obviously in frequent conversation with legislators and legislative staff. And as this process moves forward, conversations about this topic will certainly increase. And so that is something that we plan to be having consistent conversations with them to ensure that they are up to date on the current thinking of the working group and its subcommittees and understand sort of the progress as we're moving forward.
Excellent. So Mr. Green and Ms. Liberty, if your questions are answered, you can take your hands down. If they aren't, let's make sure we still do that. And then Ms. Alkenbrock, you had a question or comment.
Just to follow up on Micah's questions, is what's going to happen that our groups, the 2 different subcommittees, are going to put together recommendations and then and until that point in time, like a final set of recommendations, and then it's going to go to public comment, and then it's going to go to the Supreme Court and the legislature. So basically after 2 years, that's the process, or is there going to be incremental steps along the way in which certain recommendations are going to go before different, either the legislature or the Supreme Court for either comment or approval or something like that?
Well, I'm going to ask anybody on the call who wants to correct me if I'm wrong to do so, but I think I would answer that by saying, as Ms. Herskowitz just said with regard to informal staff level communications, and obviously we're privileged to have 2 staffers from the Supreme Court with us every step of the way, we have channels for informal feedback, but we don't anticipate this committee will, or its subcommittees, will directly request any kind of formal response from either the legislative or the judicial branch until we're finished. Well, we won't, period, because what we do is we write a report that we give to the state bar. And then it's up to the state bar in the first instance to say, yeah, fine, no thanks, or to say, yeah, okay, we want to promote this. And if the state bar board receiving our report decides they want to promote it, then they will promote it for formal action to the legislature and the Supreme Court. That won't be anything that our working group does, but we do want to be very mindful of any informal feedback we get from either branch as we go along, because we obviously all want the hard work we're doing to lead to something happening as we, at the end of this process, will be recommending, rather than to a report that just sits on the shelf. Anyone want to refine that answer?
Justice Tucker, if I could just add a piece to that, that it comes from you, but to remind the group, we were encouraged in our exercise to really think about both alternatives and the pros and cons of the various things. And that's how you see the memo written. And I think in the end, to Marta's point, our report might say, as a rule, as a group, the committee feels like, 2 or 1A is the best choice. We have the most consensus around that. But we're also laying out, a next best or a second also supported option for everyone that's reading the report to consider, so that, we have that, I guess, collaborative sort of feel to what's being happened, as opposed to we decided on this way and only this way, and nothing else can be ever considered again.
I think that's a very good point, and it goes beyond just the question of choosing options for where our sandbox structure fits in the constitutional scheme, but also to, I like to think, how high are the walls on the sandbox, or how big is the sandbox? Are we going to have a targeted one or a less targeted one? On many of the questions where we are making important policy judgments, while it's important for us to come up with a recommendation, our recommendation on a number of important issues can and should include alternatives.
And the only thing that I might add, Justice Tucker, is there is always the possibility that we would send particular concepts out for informal public comment as the process is working its way through. So not waiting till the end of 2 years, but sort of highlighting maybe key concepts and getting public comment, informal public comment on that, sort of in addition to, the concept of bringing in, focus groups or advisors who might provide input. But, sending something out, as was similar to the process that was done with ADLs. I think as we move forward, we'll get some more insight into, oh, that might be appropriate in this particular instance. And then, that would be the way that we would go. And so we'll sort of follow the momentum of the work. But I do just want to put out there that that's certainly a possibility for us to consider.
That's an important point. Thank you. Any other responses to Ms. Alkenbrock's question? Okay. Then let's talk a little bit more about the specific proposed structures, admitting that we're not yet getting to questions like funding and board structure and all those sorts of things. It sounds like our committee has recommended A1 and A2. Is there anybody who finds themselves thinking either that they don't fully understand what A1 and A2 are supposed to look like, or why would A1 or A2 be superior to the other models considered, or other models not considered? Okay, unless someone brings in a contrary answer, it sounds like we're fast moving towards a consensus that A1 and A2 are a good idea. Let me ask the committee a question, and it comes from the point that we might be able to bring in aspects of some of the other proposals into A1 and A2. A1, the idea of a sister organization to the bar, presumably much smaller organization, but that also sits under the Supreme Court, has its own board, has its own budget, is authorized by the legislature, even if not the Constitution. That's something that the State Bar has that our sandbox will not. But in many ways, it would be a sibling organization to the State Bar. Is it possible that that organization, at least while it's a fledgling sandbox, could contract with the State Bar for, let's say, IT services, HR services, GC services? I don't know why it's just the services that have initials, but basically for the sort of back office already in place. We got people hired who can do this kind of work at the State Bar. We obviously can't use them for free in the sandbox because the State Bar is paid for by lawyers, and this is a different organization. But could the different organization that is our sandbox contract with the State Bar for some of those sort of back office services?
I think I could try to answer and give a sense of what we were thinking about. I mean, I don't think anybody wants to create out of whole cloth a new, administrative agency. And I think that depending, of course, on the critical question of, how big is this going to be? What will the organization be actually doing? Of course, threshold questions that we can't answer right now. But I think that there's certainly the expectation that this organization would be able to kind of partner with in a contractual way, whether it be it the Judicial Council or the State Bar, somebody who already has all these things set up so that it'd be possible to have this parallel agency that utilizes some of the services, but in a separate way. I think that the concern, as you can see from the report, is to establish enough of a separateness so that participants in the sandbox and the general public have confidence that what the sandbox is doing and the decisions that are being made are truly independent and independent of the bar and independent of lawyers. So that's the prominence that's given to to trying to move this out of the sphere of the bar's direct activities. I don't think that contracting for certain services with the bar would have a damaging effect in terms of perception of separateness, but it would be something to be careful of.
Let me echo what Marie just said. I agree with that. I think the answer is potentially yes, but we don't know. You could come up with a scenario where all the backroom functions and others so impact the work of the committee that in fact the independence that we are looking for is potentially compromised. And I'm not for a second saying that that's what's going to happen. I'm just saying that potentially that's an issue. So the other issue is an area that I know next to nothing about, but the rules governing governmental bodies or quasi-governmental bodies contacting with each other is something that somebody who has expertise will need to take a look at. So I will again echo what was just said, which is potentially yes, but we will. The question will need to be considered when we have a better system and more knowledge about how it's being built up, which again is why getting outside expert assistance on this would be helpful.
Is there anybody who has concerns about or wants to comment on the process point that what we should do next is ask for some outside assistance from lawyers in evaluating the option or options we think is best? Okay, seeing no comments. Oh, Ms. Liberty, excuse me. You're on mute. Please unmute yourself.
Thank you. I just have a question. Do we have counsel available to us on this committee? And can we get an opinion from someone in the State Bar's General Counsel office about one, getting outside legal assistance, whether there is an actual conflict, whether any sort of hiring or contracting requires a request for proposal. I know, the State Bar is audited frequently, or at least it was when I was on the State Bar Board of Governors. It's probably the same. So I would just want to make sure that before we make any decisions, we know kind of the legal parameters that we should be as committee members operating under.
That's a very good question. And I know that the State Bar was consulted in the subcommittee's work coming up with this recommendation. And so I think someone from the State Bar is going to be able to give you a good answer. Can I ask?
And so, and I'm going to turn it over to Brady Dewar in just a second. And that was actually, Micah, that was one of the comments that I was making when this discussion happened in the working group, that like, let's sort of bring some of the initial questions that we have, figure out what the questions are in working with our Office of the General Counsel, and then figure out sort of from there, if we have a need to bring in sort of extra expertise in order to resolve some of these questions, if we have the in-house expertise to respond, because I can't quite fully get my arms around what the assignment would be at this point to the pro bono council. And so Brady, let me turn it over to you.
Yeah, I would just say we the Office of General Counsel it can definitely address any ask. So we need sort of the question, and then what typically happens in these arrangements, and we've had other advisory groups we've worked with, is that for the most part, we handle them in-house. We do have the resources, but if it was a decision that we made with our client in the State Bar that getting outside help would be appropriate, then that's a decision that we would make with the State Bar leadership. But it's sort of, we take in the question and then figure out which way to go next. What I would also say is that, given that this is an advisory body and hears from experts all the time, you are free to get information from attorneys who would like to speak to the group or provide you with information. That wouldn't be an attorney-client relationship you'd be forming. That would need to go through official processes. But as far as just getting advice or having a speaker speak about their opinion or their work in this area, that's something that's entirely within the working group and the committee's ability.
In light of those comments, and they were very helpful, let me suggest as a goal for this conversation, why don't we as a working group attempt to come up with the charge for the lawyers that we would like to give coming out of this meeting. We would like lawyers to tell us X, Y, and Z. Then we'll let the State Bar tell us the extent to which they're comfortable doing that in-house, the extent to which they would like to contract that out. And if the SAGE subcommittee would like to separately get expert advice, not subject to the to establishing an attorney-client privilege, but simply to get advice from some other lawyers, expertise from some other lawyers, let's call it, not advice,
Information
from other lawyers, that they would be welcome to do that as well, so that the SAGE subcommittee would have the freedom to supplement whatever advice they wanted from additional sources. And we would sort of leave the exact sourcing of the advice to the State Bar and the SAGE subcommittee to work out. But what this group would do today is work out the charge. What do we want to ask the lawyers to tell us? Yes, Mr. Lund.
I guess the way I think about that, Justice Tucker, I think what we as the SAGE subcommittee are looking for is, I'll use this verb and we can articulate it, is the working group's support of the A1 and 2 options as the direction to go. And then the legal request would be, and this is the frame the way I think clients like to hear it framed, is there anything about either one of those options that is insurmountable as a barrier? Is there a problem with this that we just can't sort through because of constitutional legal constraints around structure? So why can't we do this? Is sort of the way I would phrase that, in pithy terms. And then maybe the other aspect of that is, what's the legality, is there any legal concerns around bringing in these other elements of options B, C, D, and E, such as 501c fundraising or contracted employees, that we should know something about before we come to some sort of final recommendation as a working group to the bar?
Okay, I think Tom Green has a comment also.
Yeah, probably along the same line. I think outside funding, non-governmental funding is a potential big deal for us. I think at a high level, I think we need to be very careful about that because there's lots of really interested parties out in the world. But I think that the extent to which, if at all, something that's in the A1 or A2 kind of structure, can they accept grants? Can they accept money from 501c3s or from lobbying organizations or whatever? Getting some sense of that would be very helpful. And then also the question, I think just conceptually, we need to borrow resources for this thing as much as possible. So could we get somebody assigned from the Attorney General's office? Could we get somebody to do backroom stuff or technical stuff? The circumstances under which we would do that would be very helpful to know some more about, I think.
Okay, so borrowing resources as well as contracting for them, and fundraising would be two specific questions in addition to just, do the options A1 and A2 both fly? Am I correctly capturing the charge as we've defined it so far?
Yeah, good for me. I think those are both important.
Okay. When we come back after a short break, because I want to give everybody 5 minutes in a moment, let's see if we can make progress on a few other issues. For example, I know that the subcommittee doesn't yet have a recommendation on board structure or funding, but let's see if we can make some progress on those issues, enough to figure out if there are aspects that would need to go to, that would be part of the charge we would make to our attorney advisors. Okay, any other comments before we take our 5-minute break?
I think Mary Baldwin has her hand up.
Thank you, Mary. I'm sorry I missed it. Ms.
That's
Baldwin.
okay. I was just going to say that along with the, John's formulation of the charge, the lawyers of, does this fly? I think we also want to know specific, certainly constitutional or legislative obstacles, things that, hurdles that we would need to get through to establish either of these two structures. We've really used that expertise in a very specific, directed way so that we know what we're because we're trying to assess the pros and cons. And if one of these models or both is going to require significant legislative approvals and, other specific things, I don't even know what they are because I'm not one of these lawyers that we're talking about. Let's find out what that is.
I stumbled across one of these a couple of months ago when I learned that there's a requirement in our state constitution that I think it reads something like every person licensed to practice law in the state of California must be a member of the state bar. And I thought, ooh, are we talking about licensing people to practice law in California without being a member of the state bar? That can't be, if that's what the Constitution requires. And I was persuaded that in fact, the constitutional provision does not stand in the way. But I do think that's an example of something that we would want our attorneys to opine on in a more formal way, so that we had some confidence we were not suggesting something unconstitutional.
And may I suggest, because as we've talked about, we will be having We will be running some pieces of this proposal certainly through a legislative process. And so during that process, we will be identifying things that would be required to be changed even in a sandbox environment. And so I think, identifying sort of every statutory issue that would need to be addressed right now may be more than we need to bite off at the moment. Things like constitutional barriers is something that we should probably know if that affects one of the structures, because that is a much more difficult nut to crack than knowing that if we're going through, when we go take the process through the legislature, we will have time, is all I'm saying, to figure out all of the pieces that we would need to change. But things that are, constitutional in nature, things that would pose barriers that are much more difficult to cross, I think should be a way that we can expedite the legal analysis that we're asking for.
And I just want to clarify, I did not mean by my suggestion to encompass every single aspect of once the sandbox is up and running, all of the different potential legal issues we're going to have to address. I specifically meant with regard to our structure only. So if I was unclear about that, but based on your comment, Justice Tucker, I didn't mean for you to think I was broadening it to the entire scope of what we're trying to do as a sandbox.
Got it. That's great. Thank you. So may I ask that when we come back, if any member of the SAGE subcommittee, perhaps our chairs or anyone, maybe Mr. Grunfeld, who worked on the memo, if anyone is prepared to begin to frame up what the resolution is that you would make to this committee that we would vote on, that would be great. And then that will focus us on what we want to refine about, if anything, the resolution that you offer, and then we'll be able to have a vote on it. So the things we do after the break are we consider a specific resolution. We have an initial discussion around funding, staffing, and board structure, if anyone wants to make comments on those issues. And I think we should also talk about the term of the sandbox. That's definitely not something that's going to the lawyers, but that is something that is pretty fundamental to what we're doing. And to the extent anybody has any thoughts or wisdom they want to share on that high level issue right now, that seems like an issue that it's not too soon to give some thought to. I know that's kind of getting us ahead of where the SAGE committee has been able to get so far collectively, but maybe it will help them as they do soldier on those subjects, if we have some initial discussion of that after we consider a resolution. But with all that, let's take a 5-minute break and come back in a few. Bye. Constitutional hurdles, but in addition to looking at A1 and A2, sort of at the high level, we want to look at whether the sandbox can take on 501c3 type grants for funding, whether it can borrow employees or contract with employees from the state bar or state agencies. would it be helpful to have those pieces be part of the proposal, or do you think you'll just work that out after?
You know, if I may speak to that, I think maybe we could take this in pieces. One is to determine if the working group would support A1 and 2 as the direction we should continue to go further, whether
Okay.
that's Sage Committee studying it further or legal, legal direction. And then the second piece is really more, okay, here are the areas around which we know we need some good legal analysis done. And I guess those could be part of the same resolution, or we could sort of do that in a separate element, because you're right, Justice Tucker, those specifics really relate to the areas where further study and some legal analysis and legal advice is being sought.
Justice, let me see if I can take a crack at this off the top of my head. So I think the resolution would be that we will, based on the committee and analysis done so far by the SAGE subcommittee, that the working assumption moving forward would be that A1 and A2 would be the models that will demand additional investigation as we seek to develop to see whether they are viable and optional. And in order to help with that process, working with the State Bar's General Counsel Office, assistance begun from pro bono counsel, again, in coordination with the State Bar, to explore such things as any constitutional issues that may come into play, any other hindrances, including statutory hindrances in establishing either A1, A2, any issues having to do with corporations, including contractual arrangements with other governmental body once this body is set up, and any related legal issues that will come about as initial research is underway. Is that helpful?
So let me ask Ms. Baldwin, will you take that extended version of what you proposed as a friendly amendment?
Sure. I may not entirely understand the purpose of a resolution at this point. I didn't understand that it was necessary for us to include in a resolution every piece of this charge, carry on assignment to the council. If that's a good idea to do, then absolutely, that sounds like a good way to frame it.
And may I, for the record, this is the friendliest amendment ever.
Well, I would hope so, but yeah.
I think we're all groping our way along. And so I think the important things that we need to include are the support on A1 and A2 and the support for getting outside legal assistance to address the issues, and Mr. Grunfeld did a good job of identifying them, but we could certainly add or any others that the SAGE, any related issues that the SAGE committee identifies. My screen's just been commandeered by an actual proposed resolution, which is helpful.
I just tried to throw it on the screen as fast as I could. It might not be completely accurate, but maybe this will help at least you guys get a sense of what's being proposed. Look at this one, not the top part. The top part was me just taking notes.
Okay. Well, I'm not sure viable and optional.
Sorry, I was just typing. You could take that out.
I guess I would be seeking, if we're wording this, I would be seeking to have more clarity that it's the working group, I guess preliminarily supporting either the A1 or A2 model, subject to this idea that it demands additional investigation. I think doesn't quite get to the heart of, is the committee as a whole supporting this one or the other of these approaches or not? And that's, to me, I think an important thing to have clarity about at this point.
I agree with that.
This is Brady from the General Counsel's office. And from our perspective, I don't think that we need the direction as far as the legal ask spelled out in a resolution. Perhaps for your purposes and leading up to the report, you want that level of detail, and Donna can let us know if it's helpful to her. But I think from our perspective, just working with staff, I'm hearing what the questions are, and then, we don't need it formalized in a resolution ask, and I could see ways in which that could be limiting.
Okay, so I see lots of hands raised. In the order on my screen, I have Mr. Gupta.
Well, actually, I think there were folks before me had their hands up, but
well, if you want to pass the baton to someone else, you may, but I'm just reading.
I was going to quickly say that I don't know yet whether or not I've heard a good argument for keeping option B off the table at this point. So I don't know. I would think that keeping option B would be still something that we should consider.
Okay, let's Ms. Liberty.
I'd like clarity, because it sounded like, and I can't see anyone right now because of the way my screen's displaying, but are we changing the motion to be us supporting it? The inclusion of A1 and A2, or just that we support the further research? Because if it's supporting it, there's too many questions to my mind that remain unanswered. I would never be able to vote to support anything based on the limited amount of information. So if someone could clarify what the ask is.
That's a helpful question. May I ask that the screen be unshared so we're seeing each other? I don't think we're ready to focus on text. So we'll know exactly what we're being asked to vote on when we finish putting together the proposal, but I think Ms. Liberty's point is helpful, that the proposal is at this point a sense of the group that we want that we've identified as promising candidates for further investigation. Some, A1 and A2 or A1, A2 and B, whatever it ends up being. And taking on Mr. Dewar's point that we don't need to spell out the charge, which is consistent with what Ms. Baldwin originally started with, unless someone objects. I think that seems like a simpler and therefore better approach. But Mr. Grunfeld, you have your hand raised.
Sorry, that was an old hand raise. It's now down.
I see. Okay, got it. Okay, so before we go to a specific proposal with regard to A1 and A2, we've been asked to consider whether B should stay on the list. Mr. Gupta, I don't know if you want to speak in favor of B or if anyone else does, but maybe that's the.
Well, I know that there's some concern about whether or not a nonprofit can regulate, but if we're already agreeing to have either OGC or a pro bono law firm look at this issue, I would keep it in the bag.
Okay. Anyone else want to talk about B? Does anybody have any examples that they can think of that come to mind of where a nonprofit has been a regulatory body? The closest I can think of is something like the agricultural boards, like the Raisin Board and whatnot. But I don't know if we have 501c3s that act as regulatory bodies. Tom Green.
Yeah, this is just an antitrust perspective. The A1 and 2 are much cleaner from an antitrust perspective. I mean, we're going to be, this group is going to be, this entity will be an arbiter of who gets to practice a certain kind of activity versus not. So it's potentially freighted with antitrust concerns about exclusion. So I think the key play here is a federalism play. You want the government to do this as opposed to a private group.
Right.
So the A1-2 is, both of those are much cleaner. The The B ones are certainly less clean. There are some examples of at least quasi-private organizations, FINRA, for example, in the security space. There's some others which are sort of private, but even there, they are under the direct control of, at least in the FINRA case, the Securities and Exchange Commission. So I think extra care would be required if you go with the B choices. The A1, 2 are much easier to work with, I think, from a legal perspective. But you can certainly get opinions, but I think A1 and 2 are just much easier to work with.
Is it possible that if we go with B, but have some way of clearly establishing this independent organization in the judicial branch under the supervision of the Supreme Court, that addresses the government action concern?
You could do, yeah, yes. I mean, the play here is that if you're doing something exclusionary, the state of California can do exclusionary things. It can supplant competition with regulation if it chooses. But the two-part test is you have to expressly do it as a government, and you have to actively supervise that activity. And under both of those analyses, the government has to do it. So I think you might be able to do it, but you have to be really careful about the governmental aspects of this activity, and that it's directly supervised by, in this case, the judicial branch.
So there might be a requirement for more active Supreme Court supervision if we went with model B than if we went with one of the A1 or A2 models.
Well, it would be possibly, but the secret behind it's called the state action doctrine is that you want the government to be acting as distinct from private parties. So under all circumstances, you would want to pass muster under that test. But if it's directly the state of California, presumably represented by direct supervision by the Supreme Court, all these models will work. But the A1, A2 are just a much easier lift for him.
Well, I appreciate that we have an antitrust expert on our committee able to share that off-the-cuff expertise. But also I appreciate we have a vector into the Supreme Court organization who's raised the issue. So Mr. Gupta, do you continue to believe that it would be helpful to have B on the list?
It's just really up to the group, and I'm appreciating this discussion a lot. So it's of course up to the group.
Okay, are there others on the group who want to comment about the comparative advantages of A1, A2, and B? Or the comparative advantages of getting broad advice at this point, that is to say, asking for comment on all three models?
Justice, let me jump in if I may. So the memo that was circulated to everyone explicitly said that B is something that we're not putting aside and shelving. It's something that's still in play. It seems to me that since we're going to need additional input and we're going to get outside experts to weigh in, asking them to get a little more analysis about this 501c3 option is something that I suspect they will readily do. And I'm sure that Tom's points and the issues, both advantages and disadvantages, can be further delineated, and we can be educated upon them. So in terms of getting a little more information about the option and whether it is or is not viable and its strengths and weaknesses is not something that
So I'm afraid my computer connection cut out at the very end of what you said, but I believe I understood Mr. Grunfeld's comment in a way that would endorse broadening the original proposal Ms. Baldwin gave us to being that we ask for legal advice about the feasibility of all three of these models, A1, A2, and B. Mr. Green, you still have your hand raised. Is that an artifact of a prior? Okay.
Yes, artifact, sorry.
Okay. So, Ms. Baldwin, you gave us at the beginning something that was close to a resolution. In a minute, I'm going to ask you to formalize it with a resolution that we'll ask Ms. Lee to write down, and then we can vote on it. But in the meantime, I see Ms. Gutierrez put her hand up. So Ms. Gutierrez, please.
I actually don't completely understand the B in terms of the logistics and the legalities also. So if possible, I would like to, when we seek guidance, if we can include that just to explore the options. That way we all have some more insight onto it or into it.
Okay. So when Ms. Baldwin is ready, she will give us a motion to consider that I think will respond to exactly the point Ms. Gutierrez made.
Okay, well, we'll see about that. I'll do my best, and feel free to do whatever. And I'm trying to think about the other comments that were made, all of which were, of course, good ones. How about something along the lines of the working group supports for purposes of further research and consideration options A1, A2, and B set forth in our memo of whatever date, and recommends legal research or legal advice to be provided by the Office of the General Counsel and or pro bono counsel as appropriate, or something like that.
Okay, I think we have a proposed resolution. And so Ms. Lee, if you can share it with us, and we'll let Ms. Baldwin change anything she wants to in the wording, and then we'll discuss and amend as necessary.
So just to be more specific, set forth in the memo from the SAGE, or the SAGE committee memo, whatever we're going to call it.
If you want to date, it's April 2nd.
Thanks.
Do we want to say legal analysis instead of advice, or do we want actual advice?
That's Ms. Baldwin's call.
That's okay. That's sort of one of those interesting things that I talk about for a long time with people. What is the difference? We can say legal analysis. Leaving ourselves the most room. So the point of this resolution would be to indicate if the working group does, support of these models, at least, again, good point that was made, not supporting them for purposes of this is what we want to do going forward, but supporting them for purposes of this is what we want to, take and further develop. So I think this resolution seems to get there, including the specific piece that we've been talking about the legal analysis.
Okay, thank you, Ms. Baldwin. I think we have a proposal. Before I get to the people who have hands raised, do we have a second for this motion?
Second.
Thank you, Ms. Sandifar, for seconding. And now, in the order I have them on my screen, Mr. Moore.
Yeah, the only thing I would suggest is legal analysis of what? Maybe just specify the legal analysis of the constitutional and legal feasibility of the proposals.
Okay,
isn't that what we're really talking about?
Let me just ask Ms. Lee, would you please turn on your track changes, and we'll consider this a proposed amendment by Mr. Moore?
Sure. Hold on one second.
Because I figure we should now trying to be
Okay.
formal. We'll consider a proposed amendment.
What was that again, Kevin? Legal analysis of?
Legal analysis of the constitutional and legal feasibility of the proposals.
Okay, I think I can ask Ms. Baldwin and Ms. Sandifer as seconder whether they accept the friendly amendment or want it separately voted on.
I think that looks good.
All in.
All right, excellent. So that's accepted as a friendly amendment. Ms. Liberty.
Yeah, I just want to make sure that in this case, when we're bringing in pro bono counsel or anyone else who's volunteering their time, that there's no financial conflict or conflict of interest with whomever is giving us this free advice. I assume that's just a standard policy of the State Bar, but I'd love confirmation of that.
So that's an interesting question when we're talking about conflicts in this context, because I'm sure it's an important policy always to avoid conflicts. Is there a particular kind of conflict that you're thinking about, or?
Well, I mean, the examples that come to mind is a law firm that represents a certain client that could potentially benefit under, you know, either being able to participate in the sandbox or benefit under the committee's work, or even the entities themselves, the businesses who have ideas or would like to develop applications, and they have a legal department, and that department could provide legal assistance for free. You know, I'm not, this isn't an exhaustive list. I just think we should have some sort of anti-conflict, whether it's even the appearance of a conflict or an actual conflict. We want to make sure that no one has any sort of interest or vested interest in providing legal advice one way or another.
Okay, anyone from the State Bar want to respond to Ms. Liberty's concern? Maybe that's Mr. Dewar, I don't know.
Sure, I've actually not been involved in engaging outside counsel, but our office is constantly on the lookout throughout the organization on ethics and conflicts issues. So it would certainly be a problem we would seek to avoid.
Mr. Grunfeld, I see you have your hand raised.
Yeah, as just as a matter of course, and as a foundational issue, pro bono law firms that engage in a lot of pro bono run conflict tests very carefully on every matter they take in, for a whole slew of very good and reasons. So I'm relatively comfortable that between the safeguards of the State Bar itself and the inherent obligation by pro bono counsel to avoid both conflict and appearance of conflict, it's a good point, but I think it can be addressed as we move forward on particular issues.
So I just want to say it wasn't a process question. It was more of a policy question. I just want to know what the policy is for us and the work of this committee and anyone who volunteers to help the committee, right?
Well, and at this point, I would note that, you know, Micah, you're a great example, right? So you've got a law firm. Right now, you were not required to sign a statement that says your law firm would not seek to participate in a regulatory sandbox should one be formed. So I think, you know, any of the lawyers or the non-lawyers on the committee right now sort of are in that same place where, you know, we haven't set a policy on whether or not you would be permitted to participate in the sandbox based on recommendations that were provided from this working group to the Supreme Court and the State Bar and the legislature. So I'm not certain that if there was a need to engage outside counsel at this point, I'm not sure that would put them in any different position than any of the members of this particular working group.
I'll just say, since this is being recorded, I think we should all have to sign some sort of conflicts waiver. I don't think any of us should be able to do anything that could potentially line our pockets when we're doing volunteer work in an access to justice forum. So maybe we should talk about that, and that should change.
Okay, Mr. Rothschild, you have your hand raised.
Yeah, I guess the problem I see with having strict conflict kind of rules at this point is we don't know what the conflict is because we don't know what the sandbox is. So if we don't know, how can we say we will never participate if we don't know what there is to participate in? And I guess that's sort of what Donna was saying as well, is that until we have a design, it's hard to say, oh, that's something I might be interested in or not.
Ms. Gutierrez.
Yeah, I have to echo Toby's sentiment because it is very complex. Sometimes people might not realize what the conflict is until we lay down the foundation. And I can tell you from research perspectives, like animal research or human subject research, those that are engaging in research fill out a disclosure of potential conflicts. And I don't know how the State Bar works, but there are things that are conflict of interest versus conflict of commitment. And then there's a conflict management plan. And I don't know how, like I said, I don't know how the state works with that, but we would need more details before we leave people out because of a potential conflict that we don't even realize at this point. It's too early on in the process.
Thank you, Mr. Dewar.
Sure, and I think we've strayed a little bit into the more general from the initial question about pro bono counsel, who we may or may not engage in any event. I have a hard time imagining a situation in which we would seek pro bono advice from a for-profit corporation or a legal department. But more generally, I think everyone should be aware that the State Bar does have very strict conflict of interest provisions that apply to its management staff, the statutory provisions that apply to the Board of Trustees, and certain of our sub-entities are subject to those provisions. Those are our commissions that actually are delegated some authority to make grants or make licensing decisions. Our purely advisory committees, such as this, which is putting together a report that will then be considered by the Board of Trustees, which is subject to those conflicts, is not officially subject to those conflict of interest codes, partly because we seek a diverse assortment of views from people in tech and non-lawyers, and from lawyers who, all of whom might have some interest in the topic.
Thank you. Ms. Alkenbrock. Oops, she disappeared. I show hands still raised with Ms. Gutierrez, Ms. Liberty, and Mr. Grunfeld.
No, I'm still here.
There she is. Okay, got it. Did you have a comment or question?
I did. I think Mike is raising an important point that conflicts of interest are something that we need to address. I don't know, I appreciate the gentleman's comments from the State Bar relative to their conflicts standards that they have in place thus far. But I think this is an important issue that should be addressed and should be, a reoccurring theme that we're bringing up throughout these meetings. I think it would be naive to consider what the changes that we are contemplating without acknowledging that there are a great number of entities, public and private, that are watching our work here and would like to have a say in it in whatever shape or form that may be. So I think this is an important discussion to have, and I think we should continue to have it potentially in every meeting.
Okay, are there other people who want to speak on the subject of conflicts of interest, either for pro bono lawyers or for members of the commission? Okay, I see two hands raised, Mr. DeFontorum and then Mr. Lund.
So I just wanted to mention that in the charter that was given to us by the Board of Trustees, in developing the sandbox, it specifically says the report we submit should address scope and regulatory structure of a sandbox, including funding, staffing, and governance, and explicitly refers to conflicts of interest issues for members of any governing body. And so I think that ties into what Brady was commenting before about when actual authority is wielded versus when recommendations are made. And so it is fully recognized that the sandbox that we are standing up, so to speak, will have a governing body. And I wouldn't be surprised if folks who are participating in this recommendation effort, someone on this working group, someone who assists the working group, might end up being on the governing body. And if that happens, then it's pretty clear that the structure that we create for the sandbox, if it's ultimately implemented after considering all the pros and cons, working with all the governmental stakeholders, that the people sitting on that governing body will have to abide by stringent conflict standards. Just as an existing example, the State Bar of California approves certified lawyer referral services. There are requirements and rules that lawyer referral services have a governing body. And there are specific rules that say whether those attorneys on that governing body of a lawyer referral service are allowed to take referrals from the referral service that they're governing. And so I think it is pretty clear to me that the most applicable conflict issue that has been handed off to us is for, in developing the structure of the sandbox, that the governing body has to steer clear of conflicts. Whether derivative of that or sort of filtering down from that, we have to worry about others. I think we have to see, again, what others have said about, well, what are we doing? What is the actual conflict that's at play? If you're talking about attorney legal ethics conflicts, we've got experts here who will say, if someone volunteers to be a pro bono counsel and then substantially participates and later the sandbox is created and they're hired by a client, they have responsibilities under the rules of professional conduct to protect the interests of that client from any personal, financial, or professional interest they have in the subject matter. So I think we're okay, but that doesn't mean that we shouldn't keep our eyes open and put this on the radar. But eventually we're going to be talking about the key conflicts issue that has been handed off to us, which is if we create a governing body and we decide the composition of the governing body, we also have to come up with conflict standards for them.
Thank you, Mr. DeFontorum. Mr. Lund.
I'd just like to say that I actually support the comments that have been made about disclosure and transparency in the process, and including who we're hearing from and where they're coming from and what their particular frame of view might be on the various issues, because there's a lot of interested parties. Whether we frame that in the context of conflicts of interest and sort of, if you will, sort of over lawyer it there, I guess I don't think that's helpful, because then we lose the input from people that do have an interest but have knowledge. So I really do support the idea that people, whoever's speaking to us, we have an element of transparency to who they are and where they may be coming from. And just to kind of move this ahead, I guess if it's appropriate, we could slightly amend the resolution to simply say Office of General Counsel and appropriate pro bono counsel as needed, and leave it to the process that that Brady referred to be sure that we're dealing with pro bono counsel who don't have some axe to grind or some particular interest. But to me, that word appropriate, especially in a lot of this discussion, would give us plenty of guidance going forward as to making sure we do have appropriate pro bono counsel involved.
So I'm gonna, thank you, Mr. Lund, and I'm gonna ask Ms. Lee with her track changes again to put up on the screen the proposed amendment, so I can ask whether or not it's accepted as a friendly amendment or we have to separately vote on it. Okay, do we need Mr. Lund to repeat what his proposed change is?
Yes, please.
I would just suggest putting the word appropriate before pro bono and then changing the last word of the sentence to be needed instead of appropriate. Or as needed, really, I think would almost be better.
Looks good to me.
All right, and Ms. Sandifer? Do you, as a seconder, do you accept that as a friendly amendment?
Love it.
Love it. All right. So we now have a proposal. Is there any further discussion of this motion before we vote on it? I see no hands raised, so do we need to call the question, or can we just have Ms. Lee call the roll call and take the votes now? All right, let's have Ms. Lee take the votes now.
All right. Marta Alkenbrock,
Yes.
Andrew Arruda, Mary Baldwin,
Aye.
Judge Wendy Chang,
Yes.
David Engstrom,
Yes.
Bridget Grammy, Tom Green,
Yes.
Dan Grunfeld,
Yes.
Eric Helland,
Yes.
Kathy Huang, Micah Star Liberty,
Yes.
John Lund,
Yes.
Ruby Marquez, Kevin Moore,
Yes.
Kristen Passmore, Toby Rothschild,
Yes.
Becky Sandifer,
Yes.
Jim Sandman,
Yes.
Patricia Scatera.
Yes.
Thank you.
All right, thank you, everybody. I doubt that every decision we make will be by unanimous vote, but it's nice that we start with one that is. So well done, thank you. The motion has passed and the SAGE committee can carry forward with the work that we've just authorized. And I had a whole agenda, as I mentioned before our break, of other things we could do with our discussion time, but we're down to only a couple of minutes. So maybe we'll just have to leave that in SAGE's capable hands for the next meeting. What we have starting at noon is a presentation from a couple of the Utah folks that I'm really looking forward to. I think it'll be terrific. So why don't we give everybody a slightly longer break until we reconvene at noon we can call it a lunch meeting or a working meeting if anyone wants to eat while they listen to the Utah Sandbox presenters, feel free. And we'll then roll from there into the, I don't know, I suppose we should take a formal lunch break after that, right? Of half an hour, and then we'll roll into the scope discussion half an hour after we finish hearing from the Utah presenters. So see you all in 10 minutes. Thank you. All right, please join me in reconvening. Hello, everyone, and welcome back. And to our newest member, Mr. Arruda, welcome. We'll do a formal introduction after the lunch break, which will follow the presentation that Ms. Rika and Mr. Teufel, Dr. Teufel are about to give us, which we're all very much looking forward to. And Mr. Lund, would you please introduce our guests?
I would happily do so. I am so glad to introduce you all to both Lucy Rika and Dr. James Teufel. They are the heart and soul of our Utah Innovation Office project at this point. Lucy serves as the executive director of the office. She's also a member of the task forces that have conceptualized and implemented regulatory reform in Utah going back 3 or 4 years. She's also been a special project advisor to ISLES on their Unlocking Legal Regulation project. She served as the executive director of the Stanford Center on Legal Profession from 2013 to 2018, and she remains a fellow of that center. She's also served as a lecturer at Stanford and has written on regulation of the profession, diversity in the profession, as well as the changing practice of law. And she clerked in the United States District Court for the Western District of Virginia, and received her law degree from the University of Virginia Law School. And then Dr. Teufels, one of his qualifications critically is that he's not a lawyer. He is a Master of Public Health and PhD, but he is a leader in evaluating social return on investment of medical legal partnerships as well as civil legal aid. He's innovated the financial return on investment business case for medical legal partnerships and continues to promote the social return on investment of civil justice. And I'm sure he can tell you more about what that means, but really he's promoting civil justice equity and maintaining health equity as well. He's led initiatives and developed projects and recommended policies aiming to improve the health of children and adults. He's got 20 years experience in this field. He has been employed by community-based organizations, healthcare systems, research institutes, and institutes of higher education. And he's a recognized expert in the intersection of health and civil justice. And we are so pleased to have both of them on board for our Utah project. And I'm glad to introduce you to them both and look forward to their presentation.
Okay, thanks for having us, everyone. I think I'm going to ask James to share his screen so we can go through our slides. I'll wait for that. Are you able to do that? So there's our information. We can go to the next slide, James. So we understood that you all wanted us to speak kind of at a level of detail about the actual process of regulation that we have built out in Utah and how it actually works kind of on a day-to-day basis, and specifically about the data interaction that we have with our regulated entities, which number I think, at least in terms of authorized entities, I think we have 22 or 23 at this point. And so we're happy to do that because we love to do this every day. We're really thinking about the regulatory framework that we've built out in Utah, and this has been the purpose from the beginning, in building a framework that is going to facilitate changed behavior on the part of the regulated entities and other stakeholders in the market. James, next slide. So the design brief that we kind of set out for ourselves when building out this framework was this question: how do we regulate to promote new business models and services while protecting consumers? And it's really that simple. We're really looking at building a framework that both promotes, active market participation and protects consumers, those two things. So this has meant, as you all know, a significant kind of shift in the regulatory approach from how lawyers are traditionally regulated. So there's several different aspects to this. We're moving from an ex ante regulatory framework to an ex post risk management focused framework. We're moving from prescriptive rule-based system to an objective-based regulation system. And we're moving from role regulation, the regulation of people, into entity-based regulation. So all of these things are happening at once in the Utah framework. That's a lot going on. And it's specifically a framework that allows a lot to go on. But we still need to be able to obviously regulate and enforce when we see evidence of consumer harm. And the tool that we use is this risk-based assessment of consumer harm. That is the metric that kind of captures everything together. So a little bit, just real quick, I'll run through these. You know, ex ante regulation is what we have currently in the regulation of lawyers. Heavy front end regulation focused on rules. We're moving to, in Utah, a really robust ex post regulatory framework that is focused on assessing outputs and then responding to those outputs. Next slide. Again, we're moving from prescriptive rule-based regulation, which is what we have had traditionally. That's, you know, a very detailed rule-based system that kind of tells, particularly on an economic basis, how the businesses need to be structured in order, you know, economically to do legal business. And we're moving to an objectives-based regulation, which says this is the objective that we want to reach. We want a diverse, competitive market for legal services, high quality legal services. We want that to be the goal. We're not going to say a lot about what has to happen within these structures to make that a reality. And this facilitates more bottom-up organization in the market. And again, we're moving from the licensing or certification of individual people to an entity-based sort of stakeholder unit. Next slide. So again, the real challenge has been, you know, this is sort of when we were building out in the task forces and building out the framework, you know, we identified all of those principles and all of those kind of goals for the framework. But, you know, where the rubber meets the road is like, how do you do it? And so we really focused in on, as a regulator, our mission is to protect consumers against harm that could be caused by these new entities. And that is it. That's where we're really, really focused. And again, we kind of have a dual sort of balance going on here. We use both projected risk, which is an ex ante categorization of what we consider the risk might be in any particular entity. So that kind of sets the front end framework. And then we use actualized risk, which is like the ongoing monthly data reporting that we see from these entities to regulate in real time on the back end. So projected risk and actualized risk are really like where we're spending a lot of our time right now, as John and Becky and James can attest. So this ex ante risk categorization, this is our like upfront model where we say, okay, entity, you've applied, we've looked at your model, we've asked you some questions, we understand what you're trying to do, and we're gonna give you a categorization in our kind of like framework. And that categorization is gonna have meaning for what you have to do on the back end. And this is a pretty simple categorization process at this point, because again, you know, nobody's ever done this before, so there's not a lot that we know about this, and we've essentially used the rule of thumb that the further away you get from the status quo, the higher risk we're going to classify you. So for example, you know, non-lawyer ownership and investment, it feels like a big deal, but nothing's actually changing about who's providing the services. So that's low and low moderate risk in our framework. When you change who's actually providing the services, including software provision of services or non-lawyer human provision of services, that's something new that hasn't really ever been done. And so in the United States, and so we've categorized those as higher risk. And with lawyer involvement is moderate. That means the lawyer is kind of involved in developing out the algorithm or training the lawyers and having ongoing quality control. High risk is when there's no lawyer involved at all. And an example could be a social services organization that's not a legal services organization that is using social workers to provide legal advice ancillary to their other services. And we've really, again, we've been very, very cognizant about keeping this system, trying to keep this system as focused and simple as possible on consumer harm. And so we identified these 3 consumer harms that we're worried about as a regulator. And these are basically that people get bad legal outcomes, for the lack of a better word. So, you know, they get an inappropriate or inadequate legal result. They lose out on a legal right because it wasn't identified, or they pay money for a service that they didn't need. a legal service they didn't need. So that's it. That's all we're really focused on. And we have identified these. James is going to take you through much more detail, the data templates. All of our data is really, we have really articulated to ourselves, how does this help us elucidate whether these harms are occurring in the market? Okay, so now I'm going to kick it over to James.
Great, thank you, Lucy. So what I'm going to go through first is related to some of the activity that we've seen in the sandbox to date. So it's still early days, but like Lucy mentioned, right now we have over 20 entities that have been approved to deliver services through the sandbox. But what my data will focus on is what we knew as of February. So in February, we knew we had 20 entities that were approved to be in the sandbox. How that broke out, like Lucy described, is in these categories of low, moderate, and high. We see the most common entity right now in the sandbox is a moderate risk entity. We have no high risk entities, and then the remainder are split between low and low moderate. Let me see. There we go. Okay. So there's one idea of how many entities have been approved to deliver services in the sandbox. There's the other idea, which is really important to us, of how many of those entities have sent us data so we can get at this concept of this ex post risk assessment. So we have 20 entities that were active. What you can see here is there's a disproportionate number of entities that have reported to us in that low or low moderate category. In part why that is because entities seem to take maybe a little bit longer to go from authorization to delivering services when they are in a higher risk categorization, which makes sense because they tend to be more innovative models and have to do more development or secure resources before delivering services. So based on the data that we have received to date, there are thoughts about sort of the efficiency of service delivery with the belief that as you move towards higher risk models, that there will likely be per model more services delivered. And in general, this is what we're seeing. There is a bit of a Pareto principle of what we're seeing already, where when we look at our entities and the services that have been delivered, it's really 3 entities that are providing the vast majority of those services. And it's the 2 moderate risk entities that are providing the majority of services that we have seen delivered to date. When we break that out further to try to understand what the method of service delivery is, we do see that there has been some delivery of services through software with lawyer involvement. A lot of the services have been more traditional still to date, with a lawyer involved in direct delivery of service. In part why that is some of our moderate risk entities, as they scale up to deliver services in the sandbox, may have a tiered approach where they deliver more traditional services on the front end. And as they scale and build up through time, they deliver their more innovative service, which in this case would refer to the software with lawyer involvement. When we look, we also collect data, and so we have an understanding of what type of legal services are being provided to people by legal category or legal matter. And when we see how that breaks out to date, we have over a dozen categories, but we clearly see that there is a subset of categories where most of our services are being delivered, in this case, end of life, business, marriage and family, financial issues, and housing issues. When we look at that, it makes sense because our entities that are approved tend to be specified in certain areas, and because of the areas of interest of those entities, those are the legal services that we're seeing delivered in the sandbox. Similar to what Lucy mentioned of these categories of low, moderate, and high, when we look at risk assessment, for us, for the most part, although it's a little bit more complicated than this, our low, moderate entities report similar information and data to us. Our moderate and high entities report similar information and data to us. and we engage with those buckets of entities in a similar way. So their categorization puts them into different buckets on the front end, and our ex post analysis on the back end puts them into different buckets there as well. So when we're talking about low, moderate entities in the data that we collect from them and how they're similar or different, how a low and a low moderate entity, how they're different is a low risk entity, we collect data on a quarterly basis. A low moderate risk entity, we collect data on a monthly basis. One of the primary metrics we're looking at related to harm is the idea of complaints. So we collect complaints from the entities that fall under low and low moderate risk. One of the questions is, well, what should that look like? When should you start receiving complaints, and what may those complaints look like? Now, at least if we generalize from more traditional legal services delivered by lawyers, what we know is for about every 2,000 to 3,000 services that are sought, there's about one complaint that's received. And we know that some of those complaints eventually lead to things like warning, watches, disciplinary action. But we also know that that's the minority of actions that are taken. So we do have a complaint-driven framework. When we scale, what we expect is we're going to receive more complaints. Since we haven't scaled to a large development phase yet, we're not seeing much in the way of complaints from consumers yet. In addition to the traditional complaint system, what we call it is passive monitoring plus. So we agree, like traditional legal monitoring systems, that we should collect complaints and have systems in place to respond to those complaints and do investigations around those complaints when we receive them. But in addition to the more traditional complaints orientation, we have data reporting standards from the entities. And so if entities are not reporting information to meet a standard, we also assume that's a potential risk. And in addition to the complaint data, we understand what types of services they're delivering in timeframes that they're delivering the service from start to end, how much has been paid, and in general, the location of the client or customer they're working with to deliver services. One of the things we're also working on with regard to complaints is to make sure there's improved accuracy in complaints and also more trustworthiness in complaint systems. So we're collecting information from the entities. We're improving our website to make it easier for consumers to complain. We are trying to better integrate notifications for how to complain with consumers. And one of the interesting things that could potentially be done in the sandbox, because we have a lot of tech innovation that's emerging within the sandbox, is it could be that we can integrate a complaint opportunity right into the delivery of the service on the back end of a service for the entities that are in the sandbox in the future. Our moderate and high risk entities also report complaints to us, but in addition to the complaint information and the other information that was already mentioned about the timing and the category of services or category of legal issues being addressed, we collect information on outcomes, the services sought and received, the amount paid, and those are all passive systems, right? We're expecting the entity to give us information, or we're expecting consumers, clients, customers to contact us with complaints. For the moderate and high risk entities, we're not just taking a passive approach, we're also doing active monitoring of those entities. So in the case of a moderate and high risk entity, we're going to do expert audits, which we're piloting that approach now. And also a secret shopper approach in order to further understand what's going on with the entity and further try to risk identify, and if there is a risk of harm, to mitigate that. So we try to use a passive plus approach with additional information for our moderate and high entities. We also use an active monitoring approach for those entities as another safeguard to prevent and identify harm. So I can pull up the spreadsheet. The spreadsheet does exist, and we're happy to share that. These are some of the elements that are incorporated into our spreadsheet that we request entities to report on a monthly or quarterly basis, depending on their risk categorization. We give them a template to structure their data, they can either use the template we give them, which is an Excel spreadsheet. In the near future will be a database that they can use to manage their data. Or if they're a more sophisticated entity, they use our spreadsheet to structure their data systems, to pull data to give it to us in a way that's meaningful and important to the sandbox. One of the last things I'll talk about briefly, and we're happy to answer questions, we wanted to lay out some of our process today, is around peer review audits and how to do that. So one of the approaches we're piloting now is in healthcare and medical care, there's something called medical record peer review. And we're trying to generalize that process to how we're going to conduct audits in the sandbox. So it'll be a peer review audit process. We will identify experts in the field. They will review files, either electronic files or traditional case files, to ensure that none of those harms that Lucy mentioned related to results, rights, or purchases are evident. If they are evident or they believe there's some poor quality related to any of those harms, we ask for them to elaborate. In addition to that, what we ask them to do is, if in the case the data reporting is not good enough to make a determination of if these things are happening, we want to know the data gaps, and then we'll address that with the entity too. So data quality is a remarkably important metric in all the things that we are doing. In general, how the peer audit will work is for each of those harm categories, a service or case file will be reviewed, and it will be rated from excellent to very poor. In the case where a rating is given a very poor or poor, we ask the auditor to elaborate on what that means to them. In addition to that, we're going to have 2 auditors for every service or case file, and in order to make sure that we're fully understanding, or as well as we can understand, what's going on with that service or case. Part of our interest, and this is an interesting thing in the sandbox, is not to simply promote that external peer review audits is an important thing, but with some of our more innovative services coming into the sandbox, what we understand and what they understand is, in order to scale and sustain an innovative model, it's not only important to do and engage in our external peer audit process well, but it's also remarkably important to take some of those concepts and integrate them into their internal quality control processes as well. And some of our entities look at this idea of a peer review audit as a bonus to them, as a value add, and they see this as an opportunity for them to improve the way that they're delivering services. So that's the very short, brief version of what we do in the sandbox at the moment, and we're happy to answer any questions.
Well, let's throw it open for questions. If you raise your hands, I'll be able to call on folks. Mr. Gupta.
Hey, thanks for this presentation. It was very, very helpful. I really appreciate it. So I'm curious to know, it sounds like you're still working on the complaint process, right? You are entertaining complaints as you receive them, or also seeing complaints as reported by your sandbox participants, right? And so I'm curious, are you considering any kind of system where you're requiring your sandbox participants to give, like, say, a disclosure form to new clients saying, hey, this is what you're getting, and if you've got a complaint, this is who you contact?
So we have, thank you for that question. We do have disclosures. Have you all been given access to our manual?
Yes.
It's long, but it is I think relatively clearly laid out. We do have disclosures that we have these qualitative upfront requirements in addition to the kind of quantitative data reporting requirements. So we have, and they're really simple. The qualitative requirements are, every entity we've created a badge that says, you know, this entity is regulated by the Office of Legal Services Innovation. If you have questions or concerns, here's where you go.
Got it.
And so every entity has to display that badge on their website. And if they have a brick and mortar, on their brick and mortar. And we took that straight from the SRA. So that's That's where we pulled that. And then we also have specific disclosures for non-lawyer owned entities and then for non-lawyer providers. So the non-lawyer owned entity, it says, depending on like how they're structured, it says basically like, this is not a law firm. You know, the services you're receiving are different, maybe different from those that you would receive from a traditional law firm. And you just need to be aware that if you have questions, concerns, you should talk to, and then the entity provides the like person who they should speak to within the entity. It also could say this law firm is not owned by lawyers, same sort of deal. And then the other disclosure is the service you have selected is not provided by a lawyer. And that means that some of the protections that are inherent to the lawyer-client relationship, and that we've tried to make the language like really clear on this, so I'm probably making it more lawyerly than it actually is. But you know, some of the protections may not be the same as those provided in the lawyer-client relationship, including the fact that like the person you're litigating against, or you know, your opposing party could be using the same service. You know, we've got a lot of family law document completion services in the mix, and so, you know, it could be either side of that case is using that document completion service, and so it's just a simple disclosure on that piece. It also mentions privilege, I believe. So we have those upfront disclosures that we require the entities to include in their terms of service or in their engagement letters with their consumers.
And just one more follow-up question. When it comes to the audits and the random audits, how do you protect attorney-client privilege and confidentiality issues as part of that audit?
Yeah, it's a fair question. We haven't, so most these audits are really targeted at non-lawyer providers. So it's basically like an upfront check, and they're not random. Every entity that's a moderate entity and a high-risk entity has to submit to an audit of the first 20 of their non-lawyer service provision. Okay. But it's really focused on trying to say, is there something wrong up front with this algorithm or with this training, you know, program that you've developed for your human non-lawyers, and if so, we want to identify it. Like, is the outputs that are coming out right away, or is there something bad there? And so actually, it doesn't really trigger the attorney-client privilege. We don't do audits of the lawyers.
I see. Okay.
And one genuine interest, I could at least speak to a genuine interest that I have, is to better integrate these data collection systems internally within the entities, right? So our more innovative entities, they already have processes in place where they collect complaint data because they see it as essentially customer satisfaction that they want to respond to. And this idea of an audit, they conduct audits already, right? So it's really moving entities that don't consider some of these processes to integrate them into their internal processes as well. So it's not just the information that we're collecting as the external sort of regulator, but trying to integrate this thought process in their business practice is something we're also trying to encourage among entities.
Okay.
Mr. Green.
Let me unmute. Thank you. This was a really interesting presentation. So a couple of questions. Let me put them both on the table. One is complaints. I mean, the system, obviously, at least for your lower level things, depends substantially on complaints. Some services people might not know. I mean, these are not folks that are expert lawyers or anything. So do you adjust your audit structure or anything to take into account that someone might not know that they've gotten a bad piece of work from an entity? That's one question. The other one is lawyer involvement. So I can imagine, you know, I mean, in worst case scenario, a lawyer and that person oversees 100 algorithms. What is that enough to put them in the lower category? Or, I mean, you know, is a little pinch of salt all you need, basically, is kind of the question. So complaints, how do you do those? And then secondly, lawyer involvement, what is it, if you can give me some color around that?
Sure. So on the complaints piece, I as I think I understand your question, it's this concern that we have with the knowledge gap, right? That the way legal services are provided, people who consume them may not know that they've gotten a bad service, right? And so yeah, we recognize that, one of the big problems, I mean, it's a problem for lawyers in the lawyer system as well, right? People don't know they've gotten a bad service. They don't know that they have a complaint. They don't know that they got the wrong legal result. They don't know that they paid for something they didn't need. And so so all the other metrics that we have are designed to help elucidate different pieces of that. So we ask, and even for some of it's not as much on the low and low moderate entities, but we do ask for, tell us what the legal area that you're offering, that this person receives services in, tell us what their specific sort of problem was or matter, for lack of a better word. And tell us when the service started and when it ended. So we get kind of the time frame of the service, and tell us how much they paid. And then we also, for the moderate and high, we actually ask the entities if they're able to provide us legal outcome data. And we really focus in on the moderate, and James can talk a little bit more about this, although it's a rabbit hole that we would be probably better not to go down at this point, but if we have follow-up questions, we can. We really we're trying to get them to identify, to think on the service level. So did this person want a will? Is that the service that they sought? Okay, so then let's track that row on the will, tell us when it started, when it ended, tell us how much they paid for that service. Tell us, is that the service they requested and the service they received, or did they request something different? And did they get upsold into a will or a trust or something like that? So we have a lot of other different data points that are kind of also coming around the complaints. And then the audit piece is meant to, again, further try to identify problems, so that we're playing more of a role up front, that it's not all on the consumer to complain.
Yeah.
And related, I think, to the low and low moderate entities are those are lawyers delivering services just in an alternative business structure, right? So those are the entities where it's complaints plus. Once you move to the pinch of salt hypothesis, right? The pinch of salt idea, once you put the pinch of salt of anything where it's non-lawyer and non-lawyer provision, you go up to moderate or high, depending on how that's delivered. So even if it's 1% of your model, you're still going up to the higher level, right? So if it's if non-lawyer or non-lawyer provision or software provision of services is included at all in your model, you go to a higher level of risk, even if it's only 1% of what you plan to do.
Yeah, but I think on your second question as well, it sounded like you wanted to know what we were talking about when we meant lawyer involvement. And so what we've said to folks is, look, the lawyer involvement category is meant to capture that you have lawyers involved in the development of this service, whether it's a software-based service or a human-based service. Lawyers involved in the development, i.e. they're involved in developing training protocols and scripts. They're involved in developing like trapdoors for when a problem is too complex to be dealt with at this level. So they're involved at the front end, and they're involved in an ongoing basis. Now, we don't put a rule in place saying, and an ongoing basis means a lawyer is checking every week at 5 o'clock and, blah, blah, blah. We just say, we mean an ongoing basis, which means a regular QC. The lawyer's providing regular QC ongoing. And so that's kind of our principle for lawyer involvement. Without lawyer involvement means the lawyer's only involved at the front end, right? They're only involved in sort of maybe helping with development of the algorithm, but then they're gone and the algorithm proceeds by itself, or the non-lawyer proceed by themselves, and no ongoing oversight is maintained, or there's no involvement at all. And so those types of entities would be in the high risk category. And that means that the office would be doing more auditing down the line. So like we would be doing random audits on an ongoing basis of those high risk entities because it's not happening from a legal quality perspective otherwise.
Great, that very helpful answers. Just one follow-up though. All of this is in your manual. I'm sorry, I've not read it yet. So this is all sort of
There's
soup to
a lot,
nuts, basically.
there's a lot in the manual, but it should, yeah, most of it should, I think everything that we've said should be in there.
Cool. All right. Thank you both.
Professor Engstrom, you're not showing, but you had your hand raised.
I turned my video off because I'm having terrible Wi-Fi issues. So for purposes of asking this question, I hope it's okay if I just leave it off. It just makes it a little more likely that my audio will come through clear. So thanks, Lucy. Thanks, James. This was really helpful, really concrete. And that's, I think, why it was so helpful. Sorry if I missed this during the presentation, but I'd love to know how many would-be entrants have not gained admission to the sandbox, and on what grounds. And I guess that could mean they formally failed. So you at the end of a process said, no thanks. Or it could be informally, I guess, where once they started to engage with you and saw what they needed to provide by way of information and maybe getting some subtle signals from you all as they provided that information, whether it just kind of withered from there and they disappeared. I'd just love to have a sense of who's not getting in and why. Yeah. Well, most have kind of gone through the process, and the court has not denied anyone at that level. There's a lot of iteration within that, right? So there's a lot of like questions that go back and forth and sort of clarification. There's a lot of clarification that happens. I think we have denied one. And it happened at the executive committee level. John, jump in if I'm wrong about that, but I think that's right. And that was because it was quite clear to us, it was a proposed service that was going to be sort of an algorithm based. The idea was to use Amazon Lex to do a chatbot, but it was quite clear that the person ostensibly wanting to offer this service didn't really understand anything about what he was proposing to do. And didn't have the accountability. Like, he ultimately wanted to kind of open source it and didn't have the accountability that we require, to be able to say, like, yes, this is working, the quality is good, the answers that are being put out by the chatbot are actually, I'm responsible for those answers. And so that we ultimately said, look, this just isn't going to work the way that you've presented it, and you're welcome to tweak it and come back, but you need to be accountable for your model, and this one is not structured like that. We do have 8 entities, I think it's 8, that have had to be put on hold because the court has paused bare referral fee arrangements. Initially when the court launched the sandbox, referral fee sharing was sort of like Arizona. Fee sharing was going to kind of exist outside the sandbox. And then they pulled it into the sandbox. And then I think they're having the rules committee do a little more work on like whether there's going to be ethical guidelines for the lawyers who want to engage in bare referral fee relationships. So 8 of the entities fell into that bucket and so have been paused.
Lucy, if I could just add, I remember there was a guy from Florida who was just a lawyer.
Oh yeah.
Wanted essentially to use the sandbox to be able to practice law in Utah. And we said, maybe you should just get admitted to the Utah bar. So, that was that.
Yeah, so we do, that's right. Thank you for that reminder. So we did have that one other piece, which was, there are only 3 sort of upfront rules in the sandbox. One is no disbarred lawyer owning over 10% of any entity offering legal services in the sandbox. The second is you can't just come from Florida to practice law in Utah using the sandbox. And that was really what he was proposing to do. And then the third is that lawyers partnering with your entities have to conform to the Utah rules of professional conduct unless you seek specific waivers of those rules. So those are the 3 rules. And so, yeah, thank you for that reminder, John. We did have that one that we said, this just isn't what this is about.
And David, I think your question is a good one. And in addition to that, there's another element which we're starting to see now of who falls out of the sandbox and why, right? So the immediate impulse in a harm framework is that we're going to find bad actors and they'll be expelled from the sandbox, and that's how they'll fall out. And certainly through time, we'll likely come across that at some point. But I would say in the short term, what's much more likely to happen is entities end up withdrawing from the sandbox because they can't do what they thought they could do and they can't deliver. And so we give entities an option to either be suspended until they can learn how to do what they're proposing to do, or withdraw from the sandbox. And if they do get to a point where they can deliver the services that they propose, they can do it at that time.
Yeah, and I should mention, there have been a couple others that have withdrawn just because I think maybe the data reporting, they didn't like it, or I'm not sure, you know, they kind of withdrew before they really started the process. And there's one authorized entity that has just withdrawn, and that was an accountant, an accountant firm in Salt Lake that had hired a lawyer, and I guess the lawyer left and they didn't have plans to hire another lawyer immediately. So they may come back, but for now they've withdrawn.
Okay, Mr. Arruda.
Hi there. Quick question. In terms of comparing to a baseline, has there been any discussions around doing secret shop or any of these similar kind of complaint aspects for a traditional law firm so that we can compare to some sort of medium? Because some of what's happening in terms of this additional QC isn't going on in the traditional practice. And so it would be hard to understand where there actually is a deviation, whereas some folks might not know the avenue to complain about the legal services they deliver from they have had delivered from a traditional outfit rather than a non-traditional outfit. I think that's a very good point, Andrew, and I think the bar might consider it. It's not, and it wouldn't be our job though. Yeah, it's mainly just because I think that what I'm seeing is anything over 1%, it's hard to compare it to anything. And then you can say, well, you can compare it to our current system where folks can complain and folks get disbarred, but that system has a lot of holes in it that it's not our purview to rethink, but it's just something to consider. Yeah, and I think James's presentation made this clear, but you know, we do see the lawyer complaint system is like the floor. I think we'd like, you know, we won't necessarily get involved in individual redress of complaints, but in terms of complaint intake, I do think we want to facilitate a much more robust informational system. Awesome.
Mr. Tuft.
Good afternoon. My name is Andrew Tuft. I'm a State Bar employee, and I also appreciate your presentation, you being with us today. I have two questions, if you'll entertain them both. However, the first one's a compound question. And that question is, I was curious about the 9 of the 11 moderate risk entities who are not currently reporting. And I'm curious, you know, what do you do about them? How often do you follow up with them? And what tools do you have to compel them to comply other than ultimately threatening to kick them out of the sandbox? That's my first question.
Let me just answer real quick on that one, and James jump in, but they're not reporting because they're not doing anything yet. As soon as they start to do anything, so if you take a look at the manual, we've kind of processized this, put a process in place for this. But what we were seeing, and James touched on this, is that kind of because the way we've set this up, folks have to get authorization oftentimes to just take the initial steps to, you know, corporate formation or, you know, raising money or what have you. So they actually there's a longer runway until they're actually ready to launch to offer legal services to the public. And so we don't make them report until they've launched, because that wouldn't make a lot of sense. And so what we have had to do though is, and this is what we tried to do in the manual, is say, like, you can't just, you got to have some sort of launch date in mind, and you got to be working toward it, because we can't waste our resources worrying about you if you're not going to get there. So we've put in place, I think it's like they have 6 months between their authorization order until they have to have set a launch date. They can request an extension if they really need to, but then they've got to explain why they need the extension. But that it's when the reporting is teed off the launch date. So those entities that aren't reporting yet haven't gotten to launch.
Yeah, I'll just reiterate quickly on Lucy's point. There's a longer latency period as innovation increases, in part because there's some infrastructure or financial build out that often has to happen. So for example, An entity may not be able to secure the capital that it needs to scale and deliver services in the way that was promised until after authorization. Whereas a lower risk entity may have a lot of their finances and infrastructure already in place. And so there's a lower latency period for lower risk entities because they're coming from a more traditional infrastructure that's already built. So the lag is primarily on latency from authorization to launch, not a lag between launching and reporting. So for example, if an entity is non-responsive to us after a launch date, and they don't send us data, then we put them into a watch category. And we communicate with them fairly sternly. If we do not receive data by the next period or very shortly and you do not respond, you will then be in warning. And if we do not get enough, then you will be suspended or expelled from the sandbox. So that period from launch to reporting, we have very strict criteria. We do have windows for the latency period as well.
Okay, that all makes sense to me, and I appreciate that. And my second question, which I hope is much easier and quicker to answer, is I was curious if there's an appeal process once someone's formally denied. So I'm thinking about the gentleman from Florida. Let's say for whatever reason, he says, I disagree with you, executive committee, you should let me in. Is there any formal quote unquote appeal process for any applicant should they be denied?
Yes, there is.
And I apologize if this is all in your manual. I too have not gone
It is
through
in
it.
the manual.
It is.
But that's okay. I can talk
Apologize.
about it too. No, it's fine. So the standing order itself required that we set up an appeal process. So essentially what we've done is if they get denied at either the executive committee level or the board level, they have 30 days from that date of denial to request a reconsideration. And then they, if that gets denied, then it kicks up to the court. And then same thing if they get kicked out of the sandbox, for any reason, that they have the same sort of windows to appeal to the court.
Okay, thank you.
We haven't put a lot else around that. It could be as we go along, there may be more that kind of is built around that, but for now it's just real simple.
Thank you. Mr. Rothschild.
Thank you. That was very helpful presentation. You mentioned in response to a question a minute ago about the complaints and how you're monitoring them and some of them come to you. You said you don't do any complaint handling, any complaint resolution. Who does? What happens to the complaints when they come in?
So this is similar to how the SRA does it, in that the complaints are a data point for us, and they're a data point in our regulation of the entire entity.
Right.
So they feed into our ongoing kind of actualized risk assessment of the entity, and if we see enough of them, that's a problem. And we have developed out thresholds that kind of quantify that or ranges that kind of quantify that. So that's essentially what we do. We don't, if an individual is going to go to the Consumer Protection Division or is going to bring a litigation against the company, that's probably how they would end up doing it. But we're not in the business of facilitating those individual complaints. We can, it's obviously grounds for us to suspend or terminate their authorization if it reaches a substantial level, but that's how we would deal with it.
That doesn't help the complaining person. They help the later complainers, but not the current one.
Well, again, I mean, I think we have a very specific mission, and we have very, very specific bandwidth. And so, at this point, that's not part of it.
Yeah. Do complaints come directly to you, or all the complaints come in that go to the provider and you find out about them and monitor them from there?
Both ways. So we do require providers, as James showed, to at every service level, detailed case level, report whether or not there have been complaints, and if so, what the complaints are about. And then we also have ways for, through the website or calling us, that consumers can reach out to us directly. And that's really part of what the badge is about, is to say, have this visual kind of reminder to consumers, hey, if I'm not happy, I have a resource here that I can call and let them know. So yeah.
So, but when you get a direct complaint, all you do is record it as a data point. It doesn't trigger anything that would help the individual consumer.
No, we don't have the capability to do that.
Okay, understood. Does the provider have any obligation to have a complaint handling mechanism or something that would allow for the dealing with complaints?
Well, I mean, they do in that they have to be able to report to us. And so they have to be able to tell us whether or not they're receiving complaints. And in that way, they do have to have an intake mechanism. So yes, in that way.
But nothing about how they deal with it once they get it, other than telling you about it.
We haven't put any rules in place around what a provider has to do with regard to complaints. And I don't know, I mean, I don't know exactly what we would do. I mean, I think, you know, you can't really tell them what they have to, I mean, unless that was developed out statutorily, perhaps. I don't know exactly how that would work.
Okay, thank you. That's
What it does in part trigger is a conversation with the entity to understand what that complaint meant from their perspective. And there are questions related to, is there a possibility to develop an improvement plan so this does not happen again? Because one of the things that if we see, if at the entity level, if we see a complaint and we communicate with the entity and the entity does not respond, we continue to see a pattern, well, the entity could then be put into a warning watch or suspended category.
So I know there are a number of other hands before I call on them. A quick question for our presenters. We have you on the calendar till 1 o'clock, which is only 8 minutes away. Are you able to stick with us a few minutes beyond that if need be? Or is that a hard stop?
Yes, I can.
Super. So Mr. Lund, I think you have the next question.
Yeah, and this is not a question I warned you guys I was going to ask, but there's a subject coming up later on our agenda that I'm wondering if you might be able to address for us. This has to do with how one might measure the benefits to a particular consumer from a particular service. Obviously, all of your presentation has been around trying to identify harms, follow those harms, measure those harms. But we may be looking at a policy assertion that talks also about trying to assess the benefit side of a particular service. And I'm wondering if you have some thoughts on whether and how somebody would go about doing that side of it.
So Lucy, I don't know if you want to speak to that or not. This is not directly applicable to the Utah Sandbox per se, but I have over 18 years of experience off and on in trying to address those questions, right? What you're trying to get at are essentially cost effectiveness analysis, cost benefit analysis, net benefit analyses, social return on investment analyses. What often is, then what you're discussing is, what do you mean on one side or the other side, right? So one way of looking at it is, what is the money in, and what's the money on the other side? Can you take one metric that's not directly on a money scale and convert it to a money scale, right? These would be traditional cost benefit, financial return on investment, so to some degree, social return on investment analyses. And the other idea are cost effectiveness analyses, where you have some input that may not match your output. Often there's an investment made and you're looking at some other metric, right? Like access to justice or health of people or housing retained or something along these lines. It is a little bit of a different analysis. It's a different analytic method. And oftentimes with those methods, where social return on investment is often done is as a way to try to estimate those concepts, because to do the studies that would be necessary to be done would cost millions and millions and millions and millions and millions of dollars. Where social return on investment comes in is potentially looking at some of those concepts to understand what's known from the research already and estimating based on what could be known on the research that exists, what the return would be. So classic examples of this right now would be like the Stout reports around eviction. If you're familiar with those reports, this is the Stout reports do this type of concept. So it is something that can certainly be done. But in my experience, at least in doing those analyses, what also has to be considered is what would be the dream way to do it And what is the realistic and feasible way to do it? Because the dream way becomes very expensive very quickly.
Yeah, I think I don't have a lot to add other than, you know, I think it's hard. It's proved hard enough to focus on consumer harm. And we do know that the consumers we're primarily talking about are folks who aren't getting any legal assistance at all. So you could pretty easily see the benefit, or at least like theoretically. But I think one of the things that we've discovered is the narrowness of our focus is really helpful to us, I think, in our ability to execute it. We've been able to be kind of really laser focused. And because this is such a new area, I think that's been a plus for sure. And given that the relative measurement is really folks who are without help, I think that it's that setting the floor instead of like defining the ceiling is actually a really expedient way to go about it.
And if I was going to go down that path at this moment for the Utah Sandbox, I could sketch out an estimate pretty quickly, and I know it's a positive return on investment. Because of the points that Lucy made, I would just transform it into different metrics and different words to get at that same point. So it is possible to do, but it is a little bit of a different approach than what we're doing currently in the Sandbox.
If I can ask an immediate follow-up to that, how do you know that the people getting legal services through Sandbox entities would otherwise not be helped? That is to say that you are necessarily expanding the universe of people receiving legal services as opposed to simply transferring people from the lawyer-provided traditional legal services to Sandbox-provided services.
Yeah, it's a fair question. We don't know for sure. That is the vision and that is the goal. You know, our belief, and as the standing order kind of lays out, is that the opening up of this market will expand the pool generally. Certainly some of the services in our Sandbox, potentially people would have been getting services from lawyers otherwise. But we don't know that question with certainty.
Okay, thank you. Mr. DeFontorum.
Thank you, Jen, for your presentation, and probably more so for putting up with all of our questions. Actually, I just have two questions. One's a quick one. Does the regulated entities pay for the audits, and do those audits, are they mostly practice management, or do they get into operating accounts and trust accounts and that type of a review?
No, no, they don't pay for the audits at this point. You know, in the Sandbox context, we haven't asked the entities to pay for anything yet, because we really wanted to have as large a universe as possible of participants. I think the way that we've sketched it out now is that when an entity exits the Sandbox, you know, annual licensing fees would kick in. On the audit piece, no, the audit is, again, like our focus is very singular on consumer harm. And so the audit piece is this output a bad output? And if it is a bad output, what's going on? And then, you know, we'll have a conversation on the back end with entities if we're getting bad audit results to say, like, how is this happening? Is, you know, where is this an issue within the software? Are the trap doors not, you know, working correctly? But, you know, this whole system is not necessarily focused on us becoming experts in every single possible permutation of these businesses or these services, right? It's because the hope is that we have a hugely diverse market, a hugely diverse kind of range of players. The system is meant to kind of cohere the outputs so that we can say something about what's coming out and then turn to those entities and say, this is a problem, this output is a problem, and you need to fix it. And you're the expert because it's your business, so you fix it. And if we don't see a change on the output, it's still a problem, you haven't fixed it. So that's kind of the theory of regulation.
Thank you. My other question just goes to whether the data captured allows you to map between the nature of the innovative service and the type of client or consumer being served. And so I think some of your categories talk about non-lawyer ownership, and others talk about technology with or without lawyer. And I think you mentioned that you find out how much the clients are paying, but is there profile data on the income level of the consumers? And can you map that to whether the technology-oriented innovation is serving more of those lower income, or if it's the non-lawyer ownership innovation that is more so impacting, underserved or
Yeah,
unserved
so
consumers?
yeah, we've gotten this question a lot, and it kind of goes to Justice Tucker's question as well, I think. But so in our initial version of the spreadsheet, we had a significant demographic component, and we decided not to move forward with that because the feedback that we got was that consumers are never going to buy these services if they have to tell us everything about themselves. And we took that to heart. And so we, I think particularly in this day and age, there's a lot of fear around privacy and disclosure of information. And, our goal is to get this done. And so we decided that was not, we didn't want to set up that as a point of friction, right? We do have a lot of outside research interests that are going to be looking specifically at those points. And so that's one of the areas that we have said, this is going to come from our external researchers. It's not going to be part of our regulatory framework.
Thank you so much.
Ms. Alkenbrock. You're on mute, Marta.
Thank you. This has been very helpful, and I appreciate you spending your time with us today. I have kind of a granular question. Is there, and I apologize, as other questionnaires asked as well, or stated as well, if this is in your manual, but is there a mandatory requirement for each of the people in the or each of the entities in the sandbox to have professional liability coverage? And if so, is there an amount that's specified? And then the follow-up question to that is there tail coverage that's mandatory as well? For example, if an entity is kicked out of the sandbox or withdraws from the sandbox, but they've already rendered services. For example, I noticed in your presentation, one of the largest percentage of sandbox participants in Utah seems to be services that are given to people for end of life issues. So theoretically, if there's any potential problems, those might surface long after the client that retained the sandbox has passed. So, and if that entity is no longer around, what happens to those people?
The short answer is no. We have no insurance requirements for any of these entities, front end or tail. And the short answer to why is because lawyers don't have to. And again,
well, but Lucy, if I could add to that, I think the broader answer to why is because at least our working principle is it's about the market. And if a consumer is not asking a lawyer whether they have insurance or not before they do business with that lawyer, that's informative here. If people cared about that, it would become part of what people would either build into their models or not. And I guess that's the logic. It's also the logic behind this idea about determining if there's benefits to these services before we let these services be tried. The answer to the question is somebody willing to put it out there and provide it at a given expense? And is somebody out there willing to pay for it at a given price? And I think that plays to the question of the insurance piece as well, Marta.
Yeah, and just one other thing as well is, I know, and Crispin can probably speak to this, but the UK does have pretty significant insurance requirements, and I think they're expensive. It's another point of friction. It's another impediment, particularly to small, potentially innovative companies that want to come in. And so, we have not imposed that requirement.
If I can ask a couple of related questions, you can answer either or both. I was struck by the 0 in the category of high-risk entrants that you've licensed so far. And I wonder if you can hypothesize, maybe make some informed guesses as to why you have 0 high-risk model participants. And relatedly, are there lessons that you have learned from the process of iterating, especially with your moderate risk candidates, but just generally from your candidates who have gotten approved? Things that you've learned are kind of important safeguards for consumer harm that your Supreme Court required before approving things, that might be helpful for us in understanding what kinds of safeguards you all so far have found to be useful in qualifying an applicant to be licensed.
I can speak to the first part. So the lack of high-risk entities would be expected, right? So when a new diffusion hits the market, what we're seeing is a diffusion that essentially is being voiced by lawyers or the Supreme Court to other organizations and people. And so some of those high-risk entrants probably don't even know that the sandbox exists at this point, which is one thing, right? So the folks who enter first and are ready first are those people that are most similar to the organizers of the sandbox, which is largely legally focused people. And so to get for the entities everybody throws out, Amazon or Walmart or these big organizations, to get interested in something innovative will take some time. There are other things to also consider. When the Utah sandbox was created, it was a fairly short pilot time period, right? And in business, if you have a pilot period of 2 years and say it takes a year to get ready, what business people hear that as is a loss, right? They said, you want us to invest this money that we'll never recoup, right? So one of the ideas of timeframes of things is also really important, right? So it makes sense that we're not getting as many high-risk applicants yet because they probably just don't know that the sandbox exists yet. But also, depending on how sandboxes are structured, it may artificially limit some of these high-risk entities, not just because of the latency effect, because the latency effect also interacts with the period of time, say, a sandbox pilot is established. By the time they learn that this exists and understand what it means, we're at maybe 6 months less of the pilot, right? And so then it becomes a trap, right? Where once they get ready to be part, then we have to convince them why they should be part. And for business people, in one example, they would say, I'm going to lose money, so why would I do that, right? And so, I mean, that's a very simplistic answer to the question, but it's not shocking to me that that's the case. It makes a lot of sense. And there's a lot more build out around things without lawyer involvement. What does that even mean, right? There's a lot more conceptual development that has to happen in that space as well.
Yeah, I think that's, I mean, you know, we are working on getting the sandbox timeline extended if possible, but because it's quite clear to us that it's just too short. I mean, it's just from a kind of business perspective, it's just too short. And so I do think, you know, this issue, and this is an issue we faced in so many different ways. It's not just with like high risk entities, but also like engagement with community stakeholders and what have you that aren't legal first. This whole conversation, despite our efforts, right, for the most part, has been lawyers talking to lawyers about law and what a great market it is. And so, so I think, you know, we're doing a lot of work to try and push out past those boundaries and talk about this as not just a business opportunity, you know, but a social services opportunity that organizations that are not legal services organizations should really be thinking about in terms of serving their clients or serving their customers. And so the other piece of that obviously is like, you know, capital, like venture capital and the kind of private market piece of this is a challenge to have a short time frame. The same with more nonprofit organizations is, you know, they've got to raise funding. They've been told for years they can't touch this stuff, for years, forever. You know, their training is always like, here are the things you can do. You definitely can't offer legal advice. That is a terrible idea. So so now we're saying you can do that, but like that's another sort of vertical for them to build out. And so we're doing a fair amount of work on that as well.
Yeah, and just one quick point to build on Lucy's point, the nonprofit sector, right? It's different in the for-profit sector. They probably have the capital to do this, but they don't know, or they see it as too much of a risk with not enough benefit. On the nonprofit side, because that's a lot of my history, right? There's this great new opportunity out there, and then you need to get funding. But the funding is, you can apply for that next year. And then you have to wait 6 more months to get the funding. And by the time they get that money in hand, it's 2 years later, right? So we will definitely see a lag both on the nonprofit and for-profit side and for the high risk.
Those are both very helpful answers to one of my questions, and I appreciate it. Do you have anything you want to add on the other question about what you've learned based on the iterations in applications that ultimately succeeded, about what sorts of protections were important to make sure got added in applications?
So I'm not entirely clear on your question. Like, we've learned a lot about like expectation management, time management, how to write an application, but I'm not sure what you mean by protections.
Oh, ways to protect the consumer. I'm assuming that one of the reasons that an application would get denied originally and then after 3 iterations accepted is that it would add substantive mechanisms for protecting consumers that weren't in the original application, like maybe a more internal, robust process for lawyer auditing of whatever the services are, or I don't know what, but I just wondered if there were if there were things on the substantive protections for consumers angle that came out of the iterations, and maybe there aren't.
Lucy, one that comes to mind, if I may, that really came out of the court's review is on this question of lawyer oversight of non-lawyer providers. We've developed a pretty good sort of classification of what is this non-lawyer doing, and then what is the level of lawyer oversight. So for example, and so I think that iterative process that Lucy's referring to has really kind of been about clarifying what is this provider doing. And to be clear, very few of these providers, if any, are proposing to just simply run a generalized law firm and provide all manner of practice, right? They have a specific service scope that they're contemplating. But Lucy has developed a good hierarchy of, is your non-lawyer simply giving legal information, maybe akin to the Navigator program in the courthouse where it's just legal information? Is there information about legal process that's being provided by the non-lawyer? Is there actual legal advice? You know, you should do X versus Y with your application, or how you say it is basic legal advice. So they've striated that, and I think that's helped in the conversations with parties that are doing non-lawyer providers of services to help with clarity around what they're even doing. And I think that goes to the point, Justice Tucker, about harm. We're not having somebody come in and say, we want to start doing SEC filings for, you know, publicly traded companies. You take our word for it, we know how to do this. You know, it's a bit more of a focused process to really understand the service.
Yeah, although I would say those categorizations are more descriptive to cabin the order, that the authorization order, to what the entity said they were going to do. So we haven't developed enough data yet to say X or Y is a harmful approach. Once we do, then certainly we can feed that back into the loop, right? But we don't know that yet. So so really, like, a lot of the iterative process is really about making sure we understand what they're proposing to do at the level of detail that we need to understand it. And when it comes to like software provision or non-lawyer provision, it's, as John said, we've developed out these kind of these subcategorizations to those overarching categorizations that are like, but they're really descriptive. They're not rules. Like, we're not saying, well, you have to do, if you're going to have a non-lawyer providing legal advice, you have to have 2 years of training and they have to do job shadowing for blah, 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 blah. It's not rules. They're just the order just describes what they've proposed to do and holds them to that. They are then limited to that approach, right? And that's how we've sort of split that baby.
Thank you. So I don't know, Mr. Rothschild, if you intend for your hand still to be raised. If so, please ask your question. If not, does anybody else wish to raise a hand and ask a final question? And seeing none, let me please, on behalf of our working group, extend a really hearty thanks to both of you for presenting. It was really wonderful to get the benefit of your experience. Thanks for joining us. We'll now take a half-hour break and come back at 1:45 for our afternoon session. Thanks, everyone. Bye-bye. And as we're coming back online, I owe an apology to Ms. Scicchero, who I noticed put a question into the chat during the middle of our presentation just before lunch, and I didn't notice that, and we didn't get her an answer. Does anyone want to attempt to answer her question, whether in the state of California, lawyers can waive, I'm sorry, I'm not capturing it quite right. Is it allowable to seek a waiver of rules, the rules of professional conduct for a lawyer in California?
Well, we've got a lot of legal ethics experts here among Kevin, Andrew, Wendy, Mary, but let me just take a quick shot at it. It might depend on the specific rule you're talking about. So for example, if you're talking about whether a lawyer who's an advocate before a tribunal can also serve as a witness in that same matter, well, it's not that you're necessarily waiving the rule, but the rule by its own terms provides that an attorney can seek the client's consent to wear those two hats, attorney, advocate, and witness. But not all rules allow you to do that. And so there's an old case where an attorney sought to have a client waive the client trust accounting obligations. And the court said, you can't, that's not a subject of client agreement because that's a public protection rule. And so short answer is, might depend on the rule you're talking about. Conflicts rules, some can be waived by informed client consent, some might require disclosure. But I'll let any of our other sage ethics experts add to that if they want to.
Yeah, just to jump in very quickly, a client cannot waive competence or diligence in the representation in California. Absolute prohibition on doing that. But it is a question, I'm not sure, when I saw the question briefly just before the break, I thought it was asking whether you could seek a waiver of a rule from, say, the state bar. And maybe I misunderstood the question, which is what I think the sandbox is all about, that under a sandbox regime, the regulatory organization will have the authority to waive certain requirements that might otherwise cover lawyer conduct in California. So if Patricia, if you could clarify what you meant by the question, was it just a waiver by the client, or were you thinking a more broader concept?
And I apologize, I forgot her name that was presenting. I think it was Lucy, mentioned that in the state of Utah, they, she just made a comment about waiving that, and I wasn't sure how that would apply to us. And so maybe I should have asked her, but she mentioned when we were talking about accountability for the model, she mentioned that some people will seek waivers of the rules of professional conduct in Utah. And I don't know if that's a Utah specific allowance, or if this was, I've never heard of waiving the rule of conduct, professional conduct.
If I could answer that, I took a spin through the Utah Sandbox website, which is actually quite good. If you want to take a visit to that, and I looked at they have a page devoted to the approved applications, and I guess there's like 22 or 23 that are up there. And most of what the applications seem to have sought was a waiver of the application of Rule 5.4, where a lawyer was involved so that they could share fees with non-lawyer owners and so forth, where they could withstand it. But Utah recently revised, I think it was in August of 2020, their Rule 5.4 that specifically references the sandbox. But there was another application which they it was going to be a loose related organization. There are going to be three different law firms. One would provide, three different firms. One would provide legal services. One would provide financial services. And I forget what the third one was going to do. They were all going to be owned by a umbrella company that would own all three of them. And what they sought, and John can correct me on this, was a waiver of the conflicts rules, so that the conflicts of a, say, the financial services firm or a person in the financial services firm would not be imputed to the law firm necessarily, and that was granted. So I think whatever rules are established for the sandbox, I think one of the things that would probably be included is the ability of the regulatory agency, at least so long as the entity is operating within the, with the permission of the sandbox, certain rules will be waivable or deemed not applied. I don't know if I got that right, John, but I think that's how you guys operate.
Yeah, I just clarify that it is probably the same in California as in Utah, which is it's the court that can waive the rule. And so if a particular applicant needs a waiver of a particular rule, that's part and parcel of the order that the court ultimately enters that gives them that narrow specific waiver for that purpose.
Thank you
So-
for clarifying.
Yeah, that's very helpful. And it also suggests that if, rather than being directly under the court, our sandbox administrator is a separate entity and would be the one issuing the decision, that we want to make sure that that decision can include an order to waive certain kinds of rules. So we get sort of advanced authorization from the court for the sandbox entity to take that step. Interesting point. Thank you, Patricia, for raising that. Okay, so we have a very exciting afternoon agenda, but before we jump into it, I want to introduce everyone to the newest member of the Closing the Justice Gap working group. Some of you know Andrew Arruda from his work on ATOLS, but those of you who don't, he is a serial entrepreneur, currently the CEO and co-founder of Automate Medical, a health technology startup. He is the entrepreneur in residence at the Institute for the Advancement of the American legal system in Denver, Colorado. He is a special advisor to Ryerson University's Legal Innovation Zone in Toronto. I think, Mr. Arruda, you are a Canadian, but sometimes living in San Francisco as well, correct?
Yeah, full-time in San Francisco. Before I used to split my time, but COVID has me grounded.
Well, we're happy that you got grounded on our side of the border. That's great. Anything you want to add to that very brief introduction before
Just want to say thank you for having me involved. I'm really excited to be as impactful as I can and as value add as I can. And I'll be downloading a lot of info as I go, but just an honor to serve with all of you and looking forward to the impact of the culmination of all our hard work.
Well, it's great to have you on board. I'm so pleased that you can jump in, on the ground with your feet running, given your past experience in ATOLS and in all these other organizations where you've been thinking about our issues for some time. We have a full bio of Andrew in the, I guess in the staff report that's gone around or going around with our latest sort of contact info update on committee membership and all that. And I think, Mr. Arruda, that was supplied to you as well, so that unfortunately we can't take the time we did in our first meeting to have each of us individually introduce ourselves to you, but we look forward to working with you over the course of the remainder of our efforts. So with that, I'd like to turn things over to the co-chairs of our Scope Committee to report on the work of the Scope Committee.
Thank you, Justice Tucker. So I think the first item on the agenda is the actual scope. So before, I'm just going to describe what came out of the committee and maybe highlight some of the things that the public comments and other comments we got today raised there. But before I do that, I would really want to thank the group for working so hard on producing a description of a scope, which is not a sacred text, but is a description. If the staff could put that up, that would be really helpful. I hope that you've all had a chance to read it and that you've had a chance to take a look at the public comment. I'm not going to read it to you, but I am going to highlight some substantive things that it says. And I am also going to say when it came out of the group, it was not as a recommendation that this should be the scope, but it was as a statement that we all felt comfortable giving to the group to discuss as a possible statement of the scope. So there it is. If you take a look at it, I'd like to highlight just I think 3 or 4 things that I see as decision points that this statement and then the public comments point out. The first is that this says that the purpose of the sandbox is to assess a system of rules, right? To see whether changing the current rules is a good thing or not. And it defines the standard of the good thing is whether that rules change is in the public interest. So first thing, it's about testing rules. We could argue about that. The standard of testing the rules is the public interest, and it defines that public interest in terms of focusing on particular groups of the legal services market. And that's an issue where obviously the public commentators, both in writing and Bridget Graham and Crispin and the folks who talked today have some issues with that. So that's something for us to think about. Is it one way of framing that is this 100% open, or is it open only to certain kinds of applicants? The second issue is about whether benefits are something that should be assessed in evaluating this scheme, or whether harms are sufficient. So the way it is stated in the statement that came out of the committee is kind of as a utility calculation. So do the benefits of making these rule changes for the public interest substantially outweigh the harms of making these rule changes for the public interest? Most of the commentators said, get rid of the benefits. And as you heard from the Utah system, Utah does not consider benefits in thinking about whether or not to approve an entity, and it doesn't consider benefits in thinking about how to manage the whole scheme going forward. It doesn't consider that within its regulatory scope. So those, I think, are the main issues that come out of the way the group has framed this statement. So is the purpose to assess the rules? Are we assessing the rules for the public interest? What is the definition of the public interest? Does that a definition include serving the whole legal services market or only part of it? Do we assess the public interest by looking at benefits balanced with harms, or only at benefits, or only at harms, or potentially at something else? And so I'll conclude my summary there and ask if anybody either in our group wants to add anything to that. And then of course, if there are any questions from either our group or the broader group about just this sort of that framework itself.
Thank you, Professor Sandifer. It's hard for me to spot raised hands with the screen share going on. So if anyone wants to speak, please just speak up. Okay, Mr. Lund, I see you have a hand raised.
Yes, thank you. I guess this is a great start. I just have a question, I guess, conceptually around this purpose of the sandbox language. Is that, I mean, I probably maybe erroneously thought that's sort of a test, a litmus test, if you will, that would be applied essentially to each applicant. But maybe maybe what the committee is really thinking here is about sort of a broader assessment of the overall, effect of relaxing rules or altering the rules, if you will, and what the cumulative effect of that is in terms of the marketplace. Could someone maybe clarify how you all see that applying, I guess, in operation, if that's the purpose?
Anyone could jump in, but I think the history of where we arrived at that sentence was trying to thread a needle between a position that said the purpose of the sandbox is to promote innovation, full stop. And a position that said the purpose of the sandbox is to test doing something wacky and seeing if it has some effect. So that framing at all. And this was the language that came out of that kind of needle threading, I think. Now, if you look at the ISLE's public comment, ISLE's comes back and raises exactly the point that you do, John. So is the purpose of this experiment to test a system of rules, or is the purpose of this experiment to release the rules for different specific examples of what you might do and see how each of those goes? See if each of those is okay. And I think that's a great question.
And I'll just chime in as well. I think, John, you bring up a very good point. Certainly the comments about the balancing test, right? At least that language, in my mind, was more directed at, let's have the applicant make that showing in their application. And if that means we're asking them to make that showing in the application, does that mean also we want to apply the same criteria to the end result? So these are all questions that are worth discussing.
So if I could just follow up on that, how do you all envision, I guess, because it's sort of different from what we're doing in Utah, I'm having trouble imagining it. How would an applicant articulate in advance the benefits? Like, what would that sound like? How would that be assessed to weigh this to apply this test?
I think the idea is to make the applicant think really carefully about quality, right? And if you task them to say, hey, it's your burden to show that your program qualifies under this balancing test, you kind of compel them to think about quality, think about effects.
But so, okay, I hear that, but I guess, how does that then sound when they submit that in the application? There's going to be significant consumer benefits to our model in the following way. They have to say something, right? So how would, like, I guess I'm trying to figure out is that just more of a qualitative statement, do you think, that they'd need to make there? Or like when you put in a balancing test language, it seems like it's begging for a measurement.
Right. Well, again, it's asking each applicant to make that showing, and then on a case basis, right, the regulator would evaluate that.
But how would they make that showing? I guess that's what I'm trying to get to.
The best way they can. And if it includes, some speculation, at least we have more information on the end of the regulator, right, than we would if we hadn't asked the question.
Yeah.
I can say that courts are used to entertaining these sorts of balancing tests, to doing this kind of balancing project, even where data does not answer questions. So we deal with as much evidence as we can to do the balancing as fairly as we can, but benefits can't necessarily be quantified, risks can't necessarily be quantified, harms can't necessarily be quantified. And so we do the best we can with the information reasonably available, but it's at least framing the question as to the benefits outweigh the harms. Mr. Helland.
So I'll just throw this open to the subcommittee. This is the most economist of questions, so I apologize in advance. But in your benefits, if I simply said in my application, I'm going to lower price or provide a higher quality service, would that meet your benefit test? I guess I think I'm asking the same question John is, but just, it seems to me, that would be kind of part and parcel of my business model, right? I want to provide something that people can't currently afford that's of a higher quality. And I guess, is that kind of what you're thinking, that you just want them to sort of say that? You know, what's the business plan?
Let me try to step in there. I think that's a major part of it. And I think that, as was said, the purpose of asking the question is to make them think about the answer to that and share with us what their thoughts are. But I think if that's what you say, then in assessing the success of the project, if it turns out that their charges or their fees are higher than normal lawyers, or that their quality is less, that we have something to say, hey, you're not meeting what you said you were going to do, and we can address that through whatever mechanisms are built in to address those issues.
Can I just a very small follow-up question? It seems like that's, I mean, and I don't know that I'm opposed to having this language, but it almost seems like that is what Utah's doing, right? Because they're essentially saying, because I have this both, lower price or higher quality, you would almost be back to the harm category, right? That what it would really come down to is I'm actually providing a lower quality service, or I'm misleading people by sort of charging a higher price. I guess I'm just wondering if that's really a difference from what Utah's doing when they're focusing just on harm.
John can jump in about Utah's intent, but so if you're a food safety inspector, you don't care if it's a wonderful experience. You don't care if people pay a lot of money for food they hate. You just don't want them to get sick. And that is, not to trivialize it, the Utah model. Whereas my sense from the conversation in the scope group here was, we wanted to make sure that you weren't getting fake seafood as well as not getting sick, right? It shouldn't be pig intestines, it should be squid. And so I think that's maybe the difference in those two frameworks. But I do think the questions that are coming from this group and the comments that came from the public commentators are, how in the world do you implement that in the context of innovative legal services that we hope no one has ever done before? So how do you prospectively assess that, or even retrospectively assess that?
But it would be okay to say, I am providing pig intestines, but they're much cheaper and no one will be able to tell the difference that it's not squid. As long as I'm upfront with that's what I'm doing. Just to push this horrible metaphor a little too far.
So one thing I want to point out about at least the way I read the language in our purpose statement here is that it seems to me that we're talking not so much about the individual applicants, what they have to prove, as what the sandbox intends to enable policymakers to decide after this is all over. Whether when this is all over, they can say, yes, these sorts of innovations have benefits that outweigh harms. So we can, I don't know if other people read it the same way, but that's how I was reading it.
Justice Tucker, this is David Engstrom. This is certainly how I read that. I thought it was more of an ex post. Once we've gathered some data, what can we learn from it in terms of costs and benefits? I don't read this as an ex ante screen that's going to be directed at an individual would.
So Professor Sandifer, I know that the scope committee has multiple pieces to your report. Do you want to walk us through the rest of the pieces and then have us have a more wide-ranging discussion?
Well, we can do that. I think what I would pose back to you and to the broader group is, what's the deliverable we want from this conversation? So making some of the decisions that are implicated by that scope statement are foundational to many future steps that we would take. So is going through the rest of the report going to help us go back to that task and maybe even complete it today? Or should we do it and then move to the next thing? I defer to people with more experience in these kinds of groups.
Yeah, just a bit more on that. So in that statement, is the focus on unserved and underserved, which is a significant policy question. So we can certainly set that aside and go on to the other pieces, but I think the balancing test, whether it's before or after the process is completed, that's an important question. The target of this is another question, which is buried in that unserved, underserved focus. So those two things, I think at some point we're going to want to kind of grasp those nettles in whatever way we think is appropriate. But we can certainly go forward with the other bits that we were able to get perhaps more focus on, if you will. But
I agree. We're going to have to grasp those nettles. And the only reason I suggested forging on was because, well, number one, I didn't see a lot of hands raised at this point. And number two, there are some further fleshing out there is some further fleshing out, for example, in the limits on sandbox offering section that addresses this. But I don't have strong feelings as to whether we sojourn on or stick with purpose at this point. I do, in the meantime, see that Ms. Liberty has her hand raised, so please.
Thank you. I just want to get a little bit more clarity about the prior conversation. Isn't part of the purpose for us to be able to determine what the folks who want to participate in the sandbox are doing that promotes access to justice? Not talking about lower cost and, well, not talking about cost at all, but mustn't there be a nexus between their application and what they intend to do or what their goal is by participating? And should we ask them to justify that in the beginning?
Are you talking specifically about whether they should have to justify in the beginning how what they're going to do is going to close the justice gap?
Right.
So I think that is a question that reasonable minds can and have differed on, because at least the way I read this recommendation, both in the purpose section and in the later section on limits on the sandbox offerings, there is a requirement, at least at some level of specificity, that an applicant have at least a story to tell, even if no data to back it up, about how they will contribute to closing the justice gap. And then I think we got from Crispin Passmore, from Bridget Grammy, and from the Denver-based institute, whose name I can't accurately repeat, all three consistent comments saying it's a bad idea to narrow yourself to that sort of focus for a number of reasons. One point was, well, if you're trying to test the advantages of removing Rule 5.4, don't we need to look at the entire scope of removing 5.4 rather than removing 5.4 in a certain aspect of the legal market? Another point was, well, how are we going to decide what's the relevant portion of the legal market? And there were some other points as well that I trust you all have read. I'm all in favor of our engaging in the debate right now about the advantages of building a larger or a smaller sandbox, or a sandbox with shorter walls or higher walls, however you want to describe it. But I know there are some strongly held opinions on that subject. And so by all means, let's air some of that.
Yeah, I'm just wondering if it's helpful to have some of that conversation now while we're talking about scope, so we know what our scope actually is.
Absolutely, that is very much what we want to do.
If I may, Justice Tucker, our group did discuss this at some length, no surprise. And I think the guts of our conversation, or the basic elements of it, are captured in page 2 in that subsection C, limits on sandbox offerings. And I think at a high level, what that says is that I think what we reached was consensus that sandbox candidates can offer services to the unserved and the underserved. And at a high level, that includes both the obvious folks that can't afford or don't have access to it, but also may include middle-class folks as well, and perhaps small corporations. And we cross-referenced to the 2019 Justice Gap report. So that's something where we think there's an important focus. There was much debate, and I don't think any consensus on whether a company that mostly focused on, say, corporate law, but then provided services in the unserved, underserved space, whether that could come into the sandbox. So I think those are at a high level kind of the major points of the conversation that we had in the subcommittee. Becky, is that a fair?
I would just
summary?
amend that a little to say that I think there were voices in the conversation that may have piped down, but I don't think they changed their minds about not having any such restriction at all. That in fact, the sandbox would be entirely open and you could come in and say, I'm going to provide legal services to large corporate clients, and that would not be, there would be no upfront prohibition against doing that.
Yeah, I think that's true, and you and I have different views on that, but it is the case that there were polls of the debate, and I think that probably frames them reasonably well.
So let's hear from Mr. Rothschild.
Thank you. As anybody who knows me might not be surprised that I favor the more limited approach. I have a couple of thoughts. First of all, one of the suggestions was, well, if we're going to test getting rid of 5.4, we need to test it everywhere. I'm not sure that that's the charge of the sandbox. I never saw anywhere in our overall charge, reviewing 5.4 is one of the 4 rules that we're supposed to look at, that we'll be looking at in the fall or next spring or whatever. But within the sandbox, I'm not sure that eliminating 5.4 was one of our charges. Arizona did that, but it's not necessarily something that has been suggested until now for the sandbox. I think that one of the other thoughts I have is that this is going to be California is a very different place than Utah or Arizona or other places that have experimented with this, even England. It's much larger, much more diverse, much more high tech. I think the chances are that we will not be looking 6 months down the road at 20 applicants. We'll be looking at 100. And I think the resources of this entity are going to be limited. I think we probably will not have the resources to look at every possible innovation. And I think if we can focus on the name of our organization, the Closing the Justice Gap, and make that the focus of those resources that we do have, that would be very useful in moving that issue forward. And that's where I come out on it.
Thank you. Ms. Baldwin. You're on mute still. Mary, we can't hear you. Do you want to address the group?
Sorry, I was saying, I don't think I was actually next. I just popped my hand up, but Zoom put me there. I'm happy to go to the end of the line.
Okay, I have Mr. Lund next. I'm taking people in the order they are on my screen with their hands raised, so.
Yeah, I hope that's right. If Mike or Andrew thinks that they were before me, please say so. But I guess to me, this is a little bit of a definitional question about what we mean by the justice gap. And I guess I take a very broad view of that, because I think all of the lawyers on the phone know that they give a lot of advice to their families about a lot of things around the issues that might be legal issues that start off with, you're a lawyer, what do you think? And it isn't about your specialty, it isn't about what you did, it's that they're seeking some good, smart counsel from somewhere. And think about that dynamic in a corporation that has lawyers on staff. Those lawyers not only get pulled into a wider range of issues at that company than just the specific narrow things that we think of as law things, but they often become leaders in those companies because lawyers have a lot of high value to contribute to an organization. And we have this structure because I think largely of this economic constraints on the way things are, that we have created this barrier between lawyers and people who need legal advice. And they don't want to call us, you know, at $200 or $300 or $500 an hour, not knowing what it's going to cost and not knowing what they're going to get out of it. And therefore, in my view, the justice gap is much, much more than just that 85% of the people are trying to go into court by themselves. It's that there's a wide range of useful legal services that aren't packaged up and have made available to a wide range of the population by current economic abilities. And Toby, I appreciate that you've spent your life working with people that are extremely disadvantaged. But I think that to my way of thinking, the scope here needs to be contemplating, you know, not just those people that are at 200% or 400% of the poverty level and qualify for a certain type of aid, but this you know, much wider swath of people that currently are disconnected with the legal industry at all. And so I have great concern over sort of creating some barrier. I'm not even sure how you would define it when a small business becomes a large enough business that you can no longer, you know, provide services to them in this arena. It seems to me that we're going to end up losing the baby with the bathwater by trying to parse that line. And perhaps unnecessarily, I thought Crispin made some very salient points about what we do to the economics of this if we draw that line so as to somehow or another keep corporate clients from also exploring the benefits of alternative legal services. But my main point is maybe it would be helpful to figure out what we all think we mean by the justice gap. And maybe that would help with what we are thinking is the scope of this project.
Mr. Moore. I'm sorry, I shouldn't do that. You're next on my screen, but I know because I was there that Ms. Liberty has had her hand up for longer, and then Mr. Arruda.
Well, we've had lots of conversations since I first put my hand up. So my comment now is a little bit different. But I agree with what was just said. I do think we need to all have a discussion about what we think access to justice actually is and what the justice gap that we're trying to close is. I didn't read our charge ever to provide opportunities in a regulatory sandbox for corporations because they have a path, whether they're large or small, in a much different way than individuals do. I'm a plaintiff's lawyer and I work on a contingency fee basis, so no one pays me anything by the hour unless we're successful. And because of my practice areas, I represent almost exclusively child abuse victims, sexual assault victims, special needs people who've been sexually abused or physically abused, and rape victims. We provide services that go beyond just legal services, and we do that because it's a holistic way of dealing with the actual human beings who need our services. So there's a variety of things that we could be doing in this regulatory sandbox committee that would help provide more legal access to legal services, but I don't know that that includes large corporations or small corporations. So that gives you a glimpse of how I would define it. But I think it's a great idea for us to all talk about what we think our charge is.
Let's do that as we continue making comments. Mr. Arruda.
I think this is a really obviously an emotional question. I think it is something that gets to the heart of a lot of different issues. And I think the problem when this issue comes up is a lot of people speak to the issue with other thoughts and ideas behind what they're actually saying. And then it becomes really blurred as to what we're all talking about. I think we almost have to set the expectations and understand that our justice system is broken. What does justice and who gets to say what access to justice means? I think it's an absurdity for us to think that we're going to be able to define that as a group. And I actually think it's a bit condescending and patronizing for us to actually even try to set out to define that. Does it mean someone must have low socioeconomic status and then we can help them? Does it mean they have to be a victim of a horrendous crime and then we can help them? What if the person's wealthy and they get ripped off in their legal services, by an unscrupulous lawyer and they want an alternative? Is that access to justice? Who knows? I think the beautiful thing is we all know how this generally goes, especially those who are legally trained. The answer is typically it depends. And so you heard from Lucy earlier, and I think this was a really important thing that they did in Utah, which is setting the entry point, not the ceiling. And I think the problem we have here is generally, I've been in part of many groups you hear, isn't this just a Trojan horse for the big four to come in and start attacking the legal profession? What that statement in and of itself portrays, though, is the person doesn't typically say, and the big four are going to offer services that are more expensive, or they're going to offer services that are worse than or unethical than the services those folks can actually pay for, which betrays usually the person's motivation. And so if we're going to be critical about anything and what we're going to set is the goal and outcome rather than who's delivering it. Could be a corporation, could be an individual, could be, there's a new video today from Neuralink. There's a chimpanzee that can move things and objects with his mind. Who knows where we're going to go in the future with machines and humans, et cetera. But we need to stay hyper-focused on one thing. People need access to legal services. They're not getting it. The system we have is broken. And us here limiting it, this sandbox, and trying to put on all these constraints, we might as well give up because it's not going to be effective. We need to go for an entry point, let people in, and market creation is not done with market constraints. It's simple economic theory. So that's all I have to say about that.
Thank you. Ms. Baldwin, coming back to you.
Thanks. I guess I'm trying to understand how this limits on sandbox offerings might work. And I think I too am very uncomfortable about defining participants or limiting participants to only those that provide services to unserved and underserved. Even putting aside the difficulty, of defining those populations, it seems to me what we're really concerned, and this might piggyback a little bit on what Andrew just said, what we're really concerned about is getting services to people who need them, who can't easily access them right now, who can't afford them right now. And what we, part of the goal of the sandbox is to encourage innovation and creative ways to get those services to those people. And some of the ways that those services might be developed and that will be beneficial, to populations over there might also be beneficial to other populations. So it just seems like a very constricted way of, on the one hand, we're trying to encourage innovation, and then the other hand, I think this just stifles it and puts in this very artificial barrier and constraint that I think is going to be very counterproductive.
Thank you. Mr. Moore.
Okay, thank you. I guess I'm probably one of those people who is more in favor of limiting it. But the reason I'm more in favor of limiting it is if you want to have a sandbox and if you want to open it up to everyone, I'm not sure this is the body that should be devising it, because it is closing the justice gap. And even though we might not talk about unserved or underserved in the charter of this group, the whole basis of it, going back historically to the charge from the Supreme Court, asking Professor Henderson to do a report on justice gap here in California, the concept of people law as opposed to corporate law, and trying to make services available to people law. I've reviewed the a bunch of the applications in Utah. And I'm not saying that doesn't necessarily mean what we're going to get. I guess my concern is that we have to somehow bring in the basic concept of why this group is even here today. And what was the overriding concern of the Board of Trustees when they suggested bringing in Professor Henderson and directed that there be the ADLS task force. We have the paraprofessional working group, and now we have this working group. So that's one aspect of it. The concept that we're here, the sandbox is just going to be to provide innovation. And you hear people, well, we don't know what they're going to come up with, but there might be I think the word which I really hate from Reaganomics is the concept of trickle down. The benefits are going to trickle down eventually at some point. Then maybe we should start talking about how long of a term is the sandbox going to have? How many decades are we going to wait around until this is produced? The last point that I'm really concerned about is that here in California, we're going to have to get the legislature involved. And maybe this isn't something I really should be that concerned about, but we've heard that we don't have a legislative liaison. That's okay because the State Bar is in regular communication with the legislature, but they are very much a political body. And unless there is some kind of signal what this sandbox is all about, because the legislature is going to have to get involved. Are we just opening this up for anybody to provide legal services? I know Andrew just before referred to the whole idea of perhaps we're a stalking horse for the big four. I'm less concerned about that as long as we have some focus on underserved and unserved. And I think Toby said, let's at least make them think about it when they are filing their application. We talk about people come up with great ideas, they can come up with great innovations, but we need to have some emphasis that we are really looking toward the unserved and underserved. And I understand the fact that, yeah, there are a lot of people who are afraid of consulting with lawyers. They might be very concerned with the cost and everything. But I still look, I still think about from the first day I was on the ADLS task force, the focus has always been on the people law. And somehow I'd like to get that brought back into this group, this working group, that is really what we're trying to do. Thank you.
Thank you. Mr. Sandman.
I agree with Crispin and Bridget and Andrew and Isles. I think the line drawing reflected in the current draft is inconsistent with the way markets and innovation work in practice. Many innovations initially developed for profit, even those targeted at the very wealthy. Sometimes in the short term and very often in the longer term, have collateral and direct benefits for low-income people. Look at smartphones. Look at what the market for smartphones was in 2007. Look at their ubiquity today among low-income people. I think we're trying to confine innovation to a particular submarket in a way that is not going to be helpful to low-income people and to people of modest means. I also think that we might end up building a sandbox that no one wants to play in. If our invitation is to innovators and entrepreneurs to bring us projects, but limit them to projects that will serve only people who can't afford to pay anything or very little, who's going to be attracted by that? That's not a very appealing invitation to extend. So I just think there's an artificiality about the approach here that that is not realistic, and that also I think might end up ill-serving the people we all very much want to serve, low-income people and people of modest means.
So I appreciate those comments, and I want to just offer a clarifying comment or ask the scope subcommittee to help me with this. My understanding is that the recommendation is not that sandbox participants must serve only underserved and unserved legal markets, which would obviously require that we define what that means so we knew what people were limited to, but rather that they do something in their proposal to show that whatever it is they're doing would benefit those populations, whether it's because their proposal is targeted at serving those populations, or whether their proposal is targeted at offering a service that could be of broad use to many different kinds of people, but that they would ensure that, I don't know, whether it would be some portion was aimed at or some aspect of it was aimed at serving underserved populations. Can someone on the scope committee address?
Let me speak to that briefly. I think that's a correct understanding. Other members of the subcommittee may push back a bit, but I think that's correct. I mean, you can imagine, say, a technology company that's going to do wills or something. The fact that they may provide that service to wealthy people or less wealthy people, as long as they're helping us close this hideous gap in California of the unserved and underserved, that ticks the box, at least from my perspective. I can even imagine, and there was not consensus on that, if a Big Four accounting firm wanted to, scoop up some lawyers in an alternate business structure, then maybe their fix is, they're going to be doing the Googles and the Facebooks of the world primarily, but, we would expect them, I think, appropriately, I think that's the way we could handle this, to serve the unserved or the underserved. I mean, we do have a real problem in California with people that don't get legal services that badly need legal services. Google, Microsoft, Facebook don't have that problem. There also appears to be massive competition in that space in law land, fundamentally. So it's not like these guys are not getting services. The problem, which is identified initially by the State Bar of California, then in the report with some specificity, then in ATILs, again with some specificity, handing off to us this job that we're supposed to do in terms of, I think, focusing on the unserved, underserved population that was identified over this multi-year process. So letting 1,000 blossoms bloom, I don't think is our charge. We are here to help serve the people of California that are not getting services at all, or, services are deeply inadequate, I think.
Ms. Dershowitz.
Thank you. As is often the case, Jim Sandman said it much better than I could. But what I was just going to point out a couple of things. One is that the Justice Gap study, which many of us have pointed to, was actually concluded that the justice gap existed up and down the income scale. It looked at, and admittedly, it grouped it, looking at below 125% of poverty, 200, 300. It went up to 600 to 700% of poverty. So it wasn't, or higher than 700% of poverty, I think. So it didn't tell me sort of what the uber rich, feel. But up and down the income scale, the changes and how, in the extent to which there was legal assistance sought out for or provided for the civil legal problems that people experience, it went as low as, I think, the high was 86% and the low was 75% of the problems sort of did not get the assistance. So it was still really high across the income scale. The other thing that I would point out, and again, Jim talked to this same point, which is one of the things that I recall Al's talking about at length was to the extent that we are looking, if we were to limit it to those who provide services to the low income or those of very modest means, then you would likely be it'd be hard to imagine the individuals that would necessarily, as Jim said, sort of welcome the invitation, because it has to be a money-making venture for some of them in order to put down the capital to build the technology, sort of whatever the innovation might be. And so I certainly like the idea of ensuring that they demonstrate the impact on the unserved or the underserved, that they demonstrate the ability for this to be, something that can benefit those who are currently unserved or underserved. But if we were to potentially limit it to low income or modest means, I think it would lend itself to very few entrants into the sandbox.
Thank you. Judge Chang.
Okay, sorry about that. I think I've said this before, but I just want to reiterate it again. People I see in my courtrooms that need access to advice and are not getting it, it is most definitely not just people at the lower end of the economic scale. And in fact, the people at the lower end of the economic scale actually do have access to entities such as legal aid and stuff of that nature. It's people who don't qualify at that income level all the way up to probably quite a bit more than you might think that it is, that are coming in and just not having any access at all, especially if there's so I think that it's a really bad idea to be artificially limiting it at the front end. And I think in that sense, I agree with what Donna just said, to require them to show that they have it, what are they using that can actually help that income scale. I think that is good, but to limit it up front, I think you are really going to be cutting off a lot of people that need the help. The other thing I wanted to say, actually I had two other points. The second point is there a way for us, the second point was, right now, currently, entities may not appear in court without a lawyer. They have to hire somebody. And the thing is, if they have no monetary means to do so, they cannot appear, period. And so I see a whole category of people who they can't come before us at all. And I was wondering if that was an issue that we can put on our issues to discuss, analyze whether or not that makes any sense to keep that rule in place, or what's the reason for that rule in the first place. And the final thing I wanted to point is, in listening to everybody talking about wanting to focus on the low income sector, I'm not hearing any reason truly why, other than maybe that it'll direct more potential product towards the people, which I'm hearing from a lot of people on this meeting that might not be the actual impact. And the issue of resources, maybe there's not enough resource to evaluate all the proposals if we open it up. But couldn't we then put some kind of priority structure within whatever it is that we build? That priority for review will be given to those companies that are going to be giving their services to the low income sector, but we're not cutting anybody off. And so if other people have different types of products that have a downstream effect on that same population, they can still participate. We're just going to give priority in terms of review, if we have limited resources, to the people that we want to focus on. And that way we're not really cutting people off at the front end for the only issue of resources. Now, if there's another reason for it, then I think it makes a lot of sense to think about it. But if the only reason is resources, I'm not sure that's the reason to be cutting it all off from the get-go.
Judge Chang, may I ask you a clarifying question, especially with regard to your first point? I thought I heard you say that, like Ms. Hershkovitz, you endorse requiring an applicant to show what they would do for the underserved population, but that you don't want, that's on the one hand, but on the other hand, I also thought I heard you say that you're very much against artificially requiring that we only consider entrants who
No,
who are
yeah.
serving the population, at least in some way.
I think I'm not in favor of requiring it, that they show it to be able to participate in the sandbox. I would like them to show it, and whatever that is that they show will show in the priority scale where they would go if there's a limitation of resources. So if they're directly targeting that market, they go to the first of the line. If their product has impact on that product, they go next. If their product has no impact on that market, then they go last. But this is only in the terms of the limitation of resources. And that's going to be the only thing that limits the priority. If we're lucky and we get a huge grant and there's all of these resources to do it, there's no reason to limit the priority at all. Because I do agree that products that may start out in one way may, at the end of the day, have a much broader effect that we would want. And I think it doesn't make a lot of sense to me when we don't know what's coming down the line to be artificially cutting our own legs off.
Okay, thank you for clarifying. The order, I have the next three speakers unless somebody doesn't intend his or her hand to be up. We'll hear from Mr. Grunfeld, then Mr. Rothschild, then Ms. Liberty.
Thank you. A really enlightening conversation. Here's some thoughts about what the justice gap may mean, which was a point made earlier in our conversation. Let's think for a second about somebody in California who makes $1,000 a year, and somebody who makes $10,000 a year, and a third person who makes $100,000 a year, and then the fourth person who makes $1 million a year, and the fifth person who makes $10 million. So all I've done is add 1 0 at the end. There is a justice gap between each one of those categories, but it's not an equal justice gap. The justice gap between somebody making $1 million in California a year and somebody making $10 million, again, still exists, but it's not nearly as profound in terms of the cost to justice and how our judicial system and the provision of legal services impacts the vast majority of individuals. So I would think that where we should in fact focus is where the need is the most in terms of this justice gap. I will disagree with some of the things that have been said by some of my friends. First of all, there's a bit of a conflation between the people saying low income and having an underserved community. The problem in California, sadly, is that even the middle class is underserved. So, which goes to the second point, which is that the middle class, or what used to be the middle class in California, is so large and there's so many people involved that the notion of companies or entrepreneurs coming in and not trying to both make money and benefit the middle class and people close to the definition of middle class sounds to me suspect. At least it should be given a chance to see whether in fact nobody under those circumstances will come in and play in the sandbox. The issue of resources is an important one. Ultimately, we are not going to have resources to do everything. So the question is, where do we put our first priorities? And I agree with some of the things that Toby and others have said about that. And then finally, there's somebody had mentioned this. There's often the argument that when we wanted to put a humankind on the moon, and ultimately we got a GPS system out of it. But it took a while to get there. And our mission in this committee is not to get a GPS system. Our mission is to narrow the justice gap. So having a somewhat closed system, I think, will be truer to what the task is and the name of the committee where we're spending all this time working on. Thank you.
Thank you. Mr. Rothschild.
Thanks. Yeah, I agree with much of what Dan just had to say. To my mind, and people perceive me as, when I talk about underserved, talking about the very low income people that I have, worked with for 50 years. I'm really not. I'm talking about the much broader scope of the underserved community. I'm talking about the people that come into Judge Chang's courtroom. I'm talking about the range of people, and in the study, it went up, what was it, 700 or 800% of poverty. I think focusing on that kind of range, I think the concept that came out from the very beginning of this whole process with the market report, Professor Henderson's report that talked about people law, I think that might be a useful construct. I think if you provide a service that's going to focus on consumer debt problems of the middle class, that's going to have a fairly direct path to the rest of the low, moderate, middle income people. I think if you focus on something that deals with, filing SEC statements, I don't think that's going to have much chance of any downward assistance that in at least at least in my lifetime, which I hope is long, but you never know. So I think we do need to have that, some kind of limitation on it, because I don't think letting, I think if we let 500 or 750 flowers bloom instead of 1,000, we're still doing a great job.
Thank you. Mr. Helland.
Just one quick comment on what was just said. SEC filings notwithstanding, I could see, say, patents being one where, it would be very, there's small entrepreneurs who have an access to justice problem. They don't have patent lawyers, patent litigation. And I think it's just gonna be very hard for us to sort of draw a line between that. I mean, maybe we're just testing people's, entrepreneurs' ability to write a proposal to us that says, yes, we will make an effort to, go after small entrepreneurs and help them with their patent filings and litigation. But it seems to me that with a very few exceptions, this is going to be relatively hard for us to sort of draw a bright line as an underserved community or not. So to your point, it just seems like I can't quite get my head around how we would limit this, beyond making them, propose what they're doing in the actual filing. It just seems like that would be, any creative entrepreneur could come up with some way in which they can sort of reach out to an underserved community broadly defined.
Well, I think that we do intend to ask people in their applications exactly what they intend to offer and to whom. So I don't think it's inconsistent to say that we do want some showing that you, the applicant, are going to do something to narrow the justice gap. And we wouldn't use that language, but to help the people law and small business sectors that are underserved. Ms. Scattiero.
I just wanted to do a quick plug in that your understanding is the same understanding that I had, and that in terms of what Judge Chang mentioned, it's good to have it opened up, and I agree with opening it up. But if we could have a model where she proposed maybe structured, putting categories in, or these are the number of people that we need to serve in the lower end of the underserved, and that would be also helpful. But we can, I personally think we can open it up for this. The Eric mentioned patent law would be helpful, and that might not be like a divorce case, but we do need to think of how we're going to fund this. And in order to do that, especially during this economic climate, we have to make it accessible to different organizations. And then I was hoping that, in my mind, I was hoping to have sort of like a subsidy. So if we have a certain amount of richer organizations that have more disposable income that can make a innovative product that can subsidize the lower tiered costs, that would be nice. That would, and it would help us all to get this up and running in not just the sandbox, but at the end in the production. So funding is one of the questions that keeps popping into my mind. How are we going to fund this? We want to help the underserved. I definitely want to help the underserved and the low income, and they definitely need to be considered. But then how will we pay for that? And we can't just be dependent on grants, because grants are competitive and those are also limited resources.
So one advantage of a bigger sandbox or lower walls on the sandbox would be to bring in filing fees from more, let's say, a large law firm who wants to bring in some technologists or accountants or whatever, so they can offer multidisciplinary services to large corporate clients. We say that's great, but pay us X dollars to accept your application, and we'll use some of that money to defray our operating costs. Is that kind of the point you're making?
Yes. Yeah.
Thank you. Mr. Aruda.
Yeah, I think just to kind of guide things a little bit, I think we all obviously have conflicting thoughts, ideas, some of which we all agree on, but then we disagree on nuances of it. And I think we all in our minds have different ideas about what things mean, and that's natural. I think what would be helpful perhaps, and I think two ideas came out, is instead of that all-out prohibition, I think we've heard some really awesome things, which includes incentivizing those that do work in any of certain areas that have come up, landlord, tenant, et cetera, as well as I think there also could be an understanding or an agreement or a rule that's put in place that those who enter the sandbox reserve perhaps a discount for individuals who might not be able to afford the full services, so they get 30% off if people are below or fall below a certain socioeconomic status, or there could be free licenses depending on if that person went through a specific organization or group to enter and then find out about those services. So the point is, I think our time might be better served about us thinking about incentives and kind of framing things rather than finding that absolute bottom, because yes, there's a difference between 10, 100 million, 200, whatever and we're all going to disagree what those cutoffs are, it seems. But instead we can say it's open for everyone. The goal is to increase and improve access to justice for everyone in the state of California. You can bring your proposal, you can do anything, you can serve any segment of the population. We have the ability to fund it through some of the folks who are going to, have more high earning potential in that group. But then we incentivize things and we layer on certain things. And I think together we'd be able to brainstorm that much more effectively than us trying to solve the age-old question as to what is access to justice and what is justice. What does it even mean?
Thank you. Mr. Rothschild, is your hand intentionally raised?
It is. I just wanted to follow up on something that Patricia said, and that is that if you go back to the ADLES report, one of the underlying models that the ADLES report had for the sandbox was that it would be self-funding, that you'd need some startup funding, but once it's going, that unlike Utah, there would be a filing fee, there would be costs to entering beyond just having a good idea, and that would be a way of funding the operation. That was part of the basic concept from ADLES.
Okay, thank you. Right now, I don't see anyone else who wants to comment. Oh, Mr. Lund does, please.
I just want to, I think this is an excellent discussion. I think there is great value at a lot of levels in having the very first question on the application, ask the applicant, what exactly is it that you intend to do, and how exactly do you see that as affecting the needs of unserved and underserved populations? What we do with that information and how that processes, I think there's been some good suggestions. I'd hate to see us automatically exclude people because we don't like their answer to that question. And then the last piece of, just as we discussed this, we've had a similar conversation going on in Utah around the question of making services accessible to historically disadvantaged people based on race and ethnicity. And I don't know, that's a whole different discussion, but if we're going to be asking people about those things, I just think that's another element to keep at least in our minds.
Okay, thank you. We are coming close, I think, to needing a 5-minute break. So let's talk about what we're going to do after the break. This has been a wonderful discussion. I think it would be helpful to the scope committee if we come back to the question of, do we have something that we can agree on and do agree on as a statement of purpose, and or any of the rest of the items that they've prepared for our review. And if not, what do we prefer instead? And let me put a second option out there, which I suppose logistically it gets difficult, but I think it's important. Some of the commentators here and in advance of the meeting have said, who are we here on this committee to decide important policy questions like how big the sandbox should be? And as we talked about this morning, ultimately, we don't get to decide anything except what our recommendations look like. The people who decide this will be the legislature and the Supreme Court after they get whatever they get from our recommendations from the state bar. So I think this may be an area where we should get as much convergence as we can, but also consider fleshing out alternative visions. If there's a strong sense that we don't want to limit the sandbox, then we say this is what the vision looks like. But then we say, anticipating that it's possible that the political branch, the legislature who will decide this, and the I guess I should say the political branches on the one hand and the Supreme Court on the other will want a narrower sandbox, that we say, well, we also considered and would also endorse or recommend as an alternative, let's call it alternative B, a sandbox that is targeted toward entities that are more narrowly focused on on the people law sector and the underserved populations. I'm kind of getting ahead of myself, but the main point I want to make is the fact that there's a strong sense of disagreement on our committee on this potentially important point doesn't have to bog us down. We can meet it by looking for where there is common ground, and we can work around it by putting forth alternatives that would have some potential attractiveness to the ultimate decision makers, who we are not. So with those thoughts, let's take a 5-minute break and come back at 3:08, and we will then go from 3:08 until 4:30, powering through, making the best use we can of our remainder time. Thank you, everybody. We can reconvene, please. I lost track of time because I pulled out my pen and started trying to think about possible edits to our statement of purpose, and then realized, oh my goodness, that's the process that we should all be looking at collectively now. And I've let time run, so I apologize. Why don't I start by asking the co-chairs of our scope committee, do you want to propose the original purpose of the sandbox as something we adopt, or do you want to propose an amended version? Do you want to open it to the group to offer specific suggested changes, or how would you like to proceed?
I mean, it seems like, to go back to your point about how there might be two versions of vision that come out of this, perhaps we could agree, see if we could agree on the elements on which we diverge. So one of them is complete openness versus some kind of priority or incentive or something. Maybe the thing to do is can we straw poll? Do we think this is a sufficient enough division that we need two different statements, or? That seems to me to be a core decision this group has to make for its recommendation. So if we could get an action on that one way or the other, I think that would be really helpful.
Okay.
Yeah, I think I generally agree with Becky. I think, sort of breaking this out would be helpful because if we start scrivening language with 40 minutes left, I think it's going to be tough. But I, at least as I heard this, I think there's sort of a no limits at all position, which is the Passmore et al. Position. There is a position which I don't think was precisely in play, but was a straw person in this, which is participation in the sandbox would be exclusively limited to those that served the unserved or the underserved. A third position is that all of the applicants need to provide some services to the unserved or the underserved, which I think was where our group actually landed. And then finally, there is the position that it's wide open or very close to that, but that if you as a candidate do not provide any services to the unserved or the underserved, you either have to support the mission financially, support the mission of the sandbox, and or provide financial support for people that do provide services to the unserved or underserved. And then one footnote here is that I thought that there was a consensus, because the document itself references the Justice Gap report, that this does include folks in the middle class and it does include some businesses. So the unserved, underserved definition is pretty broad if you cross-reference to that position. But getting some sense of completely wide open, the Passmore position, or something that's going to be more focused or inclusive, it would be useful at least to get a sense of those two broad positions, and we can take it from there fundamentally. Becky, thoughts? Yeah.
Okay, so the straw poll is to see, I guess everybody has three options they would vote. Either I vote for a no limits sandbox, or I vote for a requirement that applicants provide some kinds of services or do something to narrow the justice gap, some kind of services for the people law sector and small business. Or otherwise prove how they are narrowing the justice gap. Is that an accurate encapsulation of the two options? And the third option would be, I can't vote between those two because, and then you can tell us why because. Okay.
Does that works? Okay.
I think we may as well go ahead and start a poll right now on that process. As long as everyone's clear on the two options that they're voting between. And I see Ms. Liberty has a comment or question before we do that.
Yeah, are we allowed to do straw polls under, I assume we follow Robert's rules, and I'm just curious about what the impact is of a straw poll if we're voting or explaining our rationale for our votes.
Okay, I will let Mr. Dewar correct me if need be, but I would say this is a non-action item. This is a sense of the group to guide the scope committee as they refine their proposals. So if, for example, we have 2/3 that votes one way on this list and 1/3 that votes the other way, then they would know, well, we have considerable support for each, but the first way is preferred. So let's write up, let's bring back to the next meeting a proposal that's consistent with that, as opposed to something else they might do if the results are very different. Mr. Dewar, should I change? You want to improve on that? You're on mute.
I would agree with that, and it's an approach that's been taken by other advisory committees of the State Bar. Use of straw polls.
So, Mr. Rothschild, you're on mute.
I just want to clarify something. To my mind, the second option, the less than wide open option, doesn't include somebody who says, well, I'm going to do SEC filings, but we'll donate, $1,000 to the local legal aid program. That it seems to me what it needs to be is that the innovation itself will provide some benefit to the underserved community, not that they're going to do something on the side that does that.
Yeah, I agree with that. I think that what he's describing is the third option, which is that they put some of their lawyers in, in a family law court once a week or something. Yeah.
Okay. Does anyone think that I'm certainly happy to agree that that's what option 2 means, that the proposed sandbox participant will do something to narrow the justice gap by the way they offer the services that they're asking the sandbox entity to authorize. It could be by simply setting aside some portion of their work to be available on a pro bono or low bono basis, or it could be something more far reaching, but it's really just something that they're offering to say why their services are going to narrow the justice gap. Mr. Moore and then Mr. Lund.
I apologize. I'm a little bit confused because I thought that Tom suggested 4 different possibilities, but is our vote now going to be on 2 different possibilities? And if that's true, I'm not sure I understand what the 2 possibilities are.
All right, that's a fair question.
I understand what they are. I'm not sure what the 4 were before.
That's a fair question.
Clarification, please.
And I went from 4 to 2 because I thought that in the end, Mr. Green did, and I thought it was easier to have 2 things to vote amongst than 4. But the 2 that Mr. Green offered that I didn't put on my list, one was a sandbox entity must be exclusively targeted at serving the underserved. I don't think anybody has requested, suggested, or endorsed that. So I propose, unless someone countermands that statement, to leave that off our straw poll. And then the 4th was they can do anything they want in terms of legal service provision as long as they pay money, whether it's to the task force entity or their local, let's say, legal services provider, to defray financially the costs of the justice gap. If anybody wants to include that, and maybe that one there's maybe more support for, so maybe that should be the 3rd option. I'll go quickly through the people who've raised hands and then try to reformulate anything that seems like consensus on what the question is. Mr. Helland.
Is it simpler just to start with wide open not? Because it does strike me that there's a group that is, sort of no restrictions, and then, and maybe I'm stacking the deck on voting, but I guess I'm just wondering, because it seems like within the wide open not, there's a question about the fee structure and so on, but it's still kind of wide open versus having some restrictions on what the proposals could be. So I wonder, to go back to your kind of initial proposal, if it's just the sense of the group is their majority for sort of wide open, and then if that's not the case, what restrictions would we like to put on it? Just a thought.
Okay, thank you. Mr. Lund.
I just want that was sort of the suggestion I was going to make, but just to add some clarity around that. While I support wide open, I also support asking the question of people, what is it that your service is going to do to help the unserved? So I'm assuming if we're supporting wide open, we're not precluding at least asking that kind of question in the process.
And to focus this, I think we are talking about the purpose of the sandbox here. So is the purpose of the sandbox to be wide open, or is the purpose of the sandbox to to target to some extent those who are interested in serving this underserved population. Ms. Baldwin.
Yeah, it's always funny when straw polls end up into this lengthy discussion about what should be in the straw poll, but that's for good reason, because we're trying to, make a meaningful vote here. And I think the question that John just asked is also, I don't know how I would vote with the options that we have in front of us, because I'm not sure I completely understand them. What I would like not to include, if we can, I don't want to include as one of the options or as part of the option, the notion that a participant could signify some type of service to the underserved or unserved population by having lawyers donate time. Their service should be something that is oriented towards providing those services. I don't think we should be counting like pro bono services or something. We haven't discussed it. That came from nowhere as far as from where I'm sitting, because I didn't participate in the scope discussion. That is a whole different discussion, which I would suggest we keep out right now.
Okay, except that I think that that when some at least of when people said pro bono services, the idea would be, okay, for example, I'm an applicant, I'm going to offer wills and estates work, and I'm going to make sure that at least 10% of my clients are, well, that's not a very good example, I guess, because everybody's in the people law sector there. But if the pro bono services are that you're going to offer the services that are sandbox regulated to pro bono applicants, I think that
okay, that's fine. I agree.
Yeah,
we're not saying that Big Law can get an application in to do something that has nothing to do with pro bono at all, and then say, oh, but never mind, we'll make our lawyers do a certain amount of pro bono on the side.
That's fine.
Okay, Mr. Rothschild, and then Mr. Grunfeld.
Yeah, I just want to clarify on the wide open versus the something less than wide open. If the issue is one of priorities or something that would give some added points or whatever, both either priority and review or added points for reaching the target audience, does that count as part of a wide open, or would wide open say doesn't matter what you do for you have an equal opportunity, and what happens with it afterwards is irrelevant?
Not sure I can answer that because I'm not sure I completely understand your question.
Okay, so we've talked about one of the options being that an applicant might have priority in the review process or priority in the approval process if their services, in fact, either target or have a clear path to the target community.
Let's leave that out and say that wide open means anybody can apply and will be considered. And whether they get considered second in line or 17th, I don't think is a major issue. Wide open means everybody can play. Targeted means you can only play, you can only enter the sandbox if you have some plan for serving underserved populations in part of the service that you offer. Okay. Ms. Scatero.
I'm so sorry. When we talk about pay to play, you didn't use that terminology. I'm using that. But the pro bono. So if an attorney uses the system, but then they allot a certain amount of pro bono cases, I have a little bit of concern with that because they, I don't know the attorneys and, benefit of the doubt and everything, but what is the quality going to look like when they know that they have, signed off on pro bono where they get busy? I was hoping that it was a structure where the pay to play structure was offering like a ticket, like a golden ticket to any of the services, so that the services can be spread out for whoever needs it rather than in-kind donation, make it monetary. So that way, if we end up finding out that we have a divorce attorney who can do X amount of cases, but they want to give a pro bono, they can do that anyway. And instead, they're going to, a large organization can subsidize the smaller or the small businesses and stuff like that. So actually having a monetary amount set aside, or the filing fees or something like that, rather than an in-kind donation.
Okay, thank you. Mr. Grunfeld.
Yeah, I think the discussion of the last 5 or 10 minutes highlights for me why we should go back to the A and B, or the 1 and 2 that we had before. I think it should go beyond just wide open. I think there's 2 basic choices between us. One is wide open, one is somewhat targeted. And how it's ultimately targeted is something for beyond the stove vote. But that's what I would that's the question that I would put in front of us as a stove vote.
Thank you. Judge Chang and then Ms. Baldwin.
Okay, I thought I understood the question, and then we started talking and now I'm completely confused. So wide open, unrestricted versus you have to have some tie or you can't participate. Are those the 2 choices?
Yes.
Okay. And if we don't agree with either of those, we
Then
want a
say,
wide open restricted, can we abstain?
Then when you get called on, you can say, I can't vote for number 1 or I can't vote for wide open nor for somewhat targeted because, and then you can fill out the, give us a quick explanation. Because it's just a straw poll, okay? Anybody else who needs to address the group before we take the straw poll? I still show hands from Ms. Gutierrez and Mr. Grunfeld. I don't know if those are, okay. Mr. Grunfeld. Oh, he's gone too. All right. So I'm going to ask our State Bar staffer to call the roll, and I'm going to ask each person to vote either wide open or somewhat targeted, or I can't choose one of those because blah, blah, blah. Okay? Go ahead, please.
All right. Because it's a straw poll, Justice Tucker, you can provide your input as well. So we'll start with you. Wide open or targeted?
I don't want to start. Thanks.
Okay. Marta Alkenbrock.
Targeted.
Targeted. Okay. Andrew Arruda.
Wide open.
Okay. Mary Baldwin.
Ms. Baldwin, you're on mute.
I'm trying to check the unmute button. I'm sorry, I'm not sure that I understand the 2 categories, so I'm going to have to pass.
Okay.
Okay, Judge Wendy Chang.
I think I have to not vote for either. I don't believe in an unrestricted wide open. I like the carrot approach that Andrew had suggested. So that's why I can't vote for either.
Okay. David Engstrom.
Wide open.
Bridget Grammy. Thought Bridget joined us. Did she drop off already?
Yeah.
Okay, Tom Green.
Targeted.
Dan Grunfeld.
Targeted.
Eric Helland.
Wide open.
Kathy Huang. Micah Liberty.
Targeted.
John Lund.
Wide open, but with an eye towards some of these incentive and qualifying conversations with applicants.
Ruby, Kevin Moore.
Targeted.
Toby Rothschild.
Targeted.
Rebecca Sandifer.
Wide open.
James Sandman.
Wide open.
And Patricia Gutierrez.
I would like it. Oh. I would like the one that we discussed, which I think it's targeted, but I'm going to say option 3. I would like it to be open enough that it's not restrictive, but having those questions. So similar to what John, I almost called you John Legend, like the music person, but I want to be able to subsidize this and fund it. So option 3.
Option 3.
I want it to be inclusive enough for underserved, but also allowing larger corporations to come in with their innovations and their monetary ability, because it's better to design a program that you can have a lot of configurations that in the end you can tailor to other types of models. More buttons in the beginning.
Okay, that's everyone.
And I passed at the beginning, but I'm not trying to hide my views. I just didn't want to start us out. I lean slightly towards the targeted at this point, but I actually am quite interested in our developing both options and reporting out both options. And so I think the fact that this group is it seems like pretty close to evenly divided between the two options nicely supports the idea that reporting out both options is a good idea. Now, we still have to have a purpose statement that speaks for both options, and we need to not become too bifurcated in what we're doing. But I think there's a lot to recommend both, even if I lean towards targeted. Okay. So that gives a little bit of guidance to the scope committee as they go back to their work. But let's return now to the, unless someone suggests something differently, and especially our scope subcommittee members, I recommend we return to our scope committee report, starting with the purposes, and see if there's room for us to find some consensus in a statement of purpose, even acknowledging that we don't have consensus as to how open or targeted the sandbox itself should be. Professor Sandifer and Tom, is that an acceptable way to go forward?
Yeah, do we want to start with that drafted statement that says the purpose of the sandbox is?
Yeah, I think so.
Would you like me to put it up on the screen?
That'd be great.
That'd be great.
Justice Tucker, let me just mention that I did note that Bridget included alternate language in her written comment.
That's true. Thank you. And anybody who wants to use that language in proposing suggestions to this is welcome to do that. I'm going to propose that we take this a sentence at a time and talk about whether there's common ground. For example, on the first sentence, the purpose of the sandbox is to monitor and assess whether modifying the rules concerning the practice of law facilitates innovation in the public interest. The split in the group does not seem to affect the appropriateness of this sentence. So I wonder whether we have a broad consensus that this is a good way to start our purpose of the sandbox, or whether there are people who would like to see us say something different right out of the box. John Lund has a comment on that question.
I guess my only thought is it seems a little passive to say the purpose is to monitor and assess. Is there an active role for the sandbox? Are we exploring? Are we experimenting? What is the group? What is the scope committee thinking those words kind of mean? That's the part I get stuck on a bit.
Someone from scope wants to grab that question.
In other words, would our group, would this group promote the innovators? Would it publicize the fact that there was a sandbox? Would it have a role in sort of developing the project, or does it simply change the rules or relax the rules and then wait to see what happens?
So this is David Engstrom. I'm most certainly, well, I'm probably not speaking for everyone here, but I think that one of the themes that came out of our conversation that we had about this as we tried to craft this was that we should approach this from a position of humility, and that the purpose of the sandbox is to generate data and examples and innovations from which others who hold constitutionally the real power here can determine whether it might make sense to do this longer term. Now, maybe I'm getting something wrong there, but if so, then I thought this sentence actually captured that very nicely. The point is to monitor and assess and to preside over a process that's going to be time bounded and that is going to generate that data and those examples that will let the legislature, the courts, whoever else, among the constitutionally empowered actors might want to make this into a longer term thing.
Yeah, I think that's certainly a fair summary of where I think our group was.
Does anybody else want to comment on that first sentence?
This is Andrew, if you'll entertain one more comment.
Sure.
I was at the scope meeting, and I'm sorry this didn't come to mind, and staffing many committees with lots of lawyers. I'm very sensitive to over lawyering language, but this did jump out to me, and I just want to raise it for the group. The first sentence only identifies quote unquote rules concerning the practice of law. And maybe that's the intent, and I'm missing it. I just want to raise, are there also statutes that are also being tested or intended to be tested by the statute, or is it only limited to rules? And I guess that's the question.
So I would offer an answer that I think rules here is the common sense, not lawyerly meaning. We're not talking about the rules of professional conduct. We're talking about the rules of the road. So it would include statutes, it would include rules of professional conduct, and it would include common law principles to the extent they apply as well. Now, of course, many of our readers will be lawyers, and we don't want to be misunderstood. So that answer isn't meant to shut down the question, but just to provide an initial response, because certainly we do want to address more than just rules of professional conduct. Mr. Moore.
To avoid any misunderstanding, can we substitute the word laws concerning the practice of law? And that should capture all three areas that you mentioned: the common law, rules of professional conduct, and statutes that govern the lawyer conduct.
So we'll put it in track changes and then see if the scope committee will take that as a friendly amendment. Substituting for rules, the word laws.
Okay. This is a question out of entire ignorance, but as a layperson, I don't think of disciplinary rules by an occupation as laws. And that's part of what we're fooling with here.
Well, I suppose we could say rules and laws.
And you know what, if Justice Tucker's explanation of what rules is intended to mean is understood by the rest of the group, that's fine with me. And I know I'm not the only one to say. I'm just very sensitive. I don't mean to diverge the focus of the group. Just something that came to me and in reading the sentence. And so I just thought I'd bring it up, but if rules is understood as Justice Tucker described it by the group, I think that is fine for our purposes, because we will know, and to those whom we report can be explained what that means. And we don't, again, over lawyering it is not intended to be a hindrance here. I just want to make sure we're all on the same page, whatever the language is that's agreed to.
Well, in the interest of not being misunderstood, I think rules and laws has some advantage to it.
Yeah.
But Mr. Green, I think you were just about to say something.
I was going to make the same point. I think, California is almost unique in having this mix of statutory requirements and ethical and rule-based requirements. So it is both technically. So I think putting both concepts in here, because we don't want to have a meta use of the word rules, because if folks are not going to understand that. I think laws and rules or rules and laws. Yeah, I think that's better.
All right, does anyone want to suggest further changes to the first sentence before we go on to the second sentence? Ms. Baldwin.
I just looking at this and just thinking about how we might be using this purpose statement going forward, it just seems a little dry. And it seems a little, by focusing on sort of rules and laws, it's not like a powerful message of innovative change. I just wonder, to me, the purpose of the sandbox is to provide an opportunity for the innovative provision of legal services in a closely monitored environment or something like that. I mean, to me, it's much more about providing the opportunity for people to do these things. And we will look at it and observe and think about and consider whether or not to change the rules. But putting the rules as first focus, and again, I may be looking at this quite incorrectly. So, but for me, that just doesn't grab me in a way that says sandbox.
Well, I think that's helpful because I think we will be using this purpose statement in many ways. It will not only appear right front and center in our report, but it could very well be part of our, let's call it sales materials, as we try to sell this idea to the political branches in the Supreme Court. And it could be part of what ends up in the application materials that go out to every potential sandbox entrant. So I like your language about provide an opportunity, and I like your language about in a closely monitored environment. I kind of missed what came in between there.
I think I said something like the purpose of the sandbox is to provide an opportunity for the innovative or innovation in the provision of legal services in a monitored and I don't know what setting or whatever it was I said, something getting to the point that of monitoring, obviously, and then we certainly do need to work in the concept of considering whether to modify the rules in light of that experience. And I didn't propose specific language for that.
Okay, thank you. Mr. Rothschild has a question or comment.
I was going to look at it, taking Mary's initial comments, slightly different language, and that is taking the current sentence and just turning it around and saying that the purpose of the sandbox is to maybe encourage rather than facilitate, encourage innovation in the public interest by modifying rules concerning laws and rules concerning the practice of law.
All right, I like
So
that too.
It puts the innovation first, encouraging innovation, but leaves in the focus on how we're going to encourage that innovation is by allowing modification of the rules.
All right, so it's obviously going to be impossible for our scribe to capture everybody's proposals. I'm writing down notes. I'm sure our scope subcommittee folks are as well. Shall we, the process question, shall we move on and have a discussion of each of the sentences and what we might do with each of them, and then sort of leave it to you all to come back with a new proposal? Or would you like to have us get as far as we can, even if it's only the first sentence or two, with something that we are voting on today? Can I ask Mr. Green and Professor Sandifer to comment on that?
Yeah, I think the second sentence, I think, is the crux of the debate we just had. So for the wide open folks, I think they just strike that sentence. For the folks that wanted targeted, they keep that sentence in some form. So I think that actually may be pretty easy. The third sentence has the balancing language, and I wasn't quite clear on how we ultimately landed on that one, but that may be a more freighted sentence than the second one. The second one's binary, use it or don't use it.
I agree. I think it might be, if we could, I mean, there's the question of, do we care about benefits or not, or do we only care about harms? And if we care about both those things, how do we relate them to each other? I think it would be great to get some sense of where the group comes down on that.
Yeah.
Because it's hugely impactful for everything that goes forward.
Well, one thing that's interesting is how different is it to talk only about benefits, for example, or to talk about benefits versus harms? Because presumably if you talk only about benefits, what you mean is net benefits, that is benefits as compared to harms.
Mm-hmm.
But I suppose either one of those is different from focusing just on consumer harm, which, as we heard today, is very much how the Utah Sandbox works. But let's see, Mr. Lund, you have a comment, and then Ms. Baldwin.
Yeah, I didn't want to throw this into the mix when we were straw polling, but it seemed a little bit, we seem to be lapping between this purpose passage and the passage further down in this memo that dealt with who could be allowed to be in the sandbox. And I took this, even though I think you framed it in terms of what the purpose ought to be, I think that question of wide open or targeted is a bit more about who's going to be let in than it is about purpose. And so I think the purpose of the sandbox, regardless of how tall the walls are, is definitely still, the public interest at issue is definitely increasing access to justice, irregardless of which of those two sides of that fence you're on. The purpose is still that interest in increasing justice. So I guess if we could word this without sort of loading into the purpose, that other question about who can be in the sandbox, I think it might flow better.
May I, in response to that point, make a specific suggestion about amending the second sentence in a way that might be agreeable to people on both sides of our divide? We would leave the first bit of it as is. The public interest to be served is increasing access to justice by providing competent legal services. But then we would put a comma and say, especially in the people law sector and the small business community in California. And the reason that it might be helpful to change to this language is that when some people read unserved and underserved, they automatically go to low income. And as our discussion revealed, that isn't what we intended. It's not what we recognize, that underserved is a much larger universe, but maybe by being more specific, we're doing ourselves a favor. And by using the word especially, maybe we can bridge our divide. Ms. Achenbrock.
My only comment to that, while I appreciate the amendment, is if I'm an innovator reading the purpose of the sandbox and I want to come into the sandbox, I'm not going to understand what people law sector means. Unless I've read all the background materials with respect to how the sandbox was formulated in the state of California. So while I appreciate that what you're trying to do, it's still a bit unclear.
I think that's a very good criticism, and I would suggest maybe saying something instead, especially in providing legal services to people and the small business community or something like that. Mr. Arruda.
Would it be too general to say, and that I'm just building on what was just said, actually, because I was going to say about the people law, it's confusing unless you know. I think would it say access to justice by providing competent legal services, by increasing access by providing affordable and competent legal services for all people and businesses in California, or all, that way it's kind of like you read that and you say, oh wow, like they're trying to bring it to the masses, including everyone in California.
I like that. Other thoughts or comments about the second sentence?
But then aren't we no longer targeted and we're opening?
Yeah, that's the problem with that.
So, but I don't think we would disagree. We want to increase affordable and competent legal services for all people in California, right?
No, I don't think you're getting disagreement with that. The question is whether that is too broad to answer our sense of our charge and our mission. Mr. Moore.
Instead of saying people, it's providing legal services to individuals and small businesses. Isn't that really what we're talking about?
Individuals and small businesses. Nice change. Ms. Alkenbrock. You're on mute.
My apologies. My hand was up. I didn't lower it. My apologies.
Oh, I see. Got it. Okay. Mr. Lund.
I support the language, individuals and small businesses, but we need to get the especially back in there so that it isn't limited that way.
And then take out the before small. Okay, other comments about this second sentence, including I don't like it. Anybody want to speak against it or propose further changes to it? Hearing none, let's talk about the third sentence. Who wants to offer a comment on whether we should keep or change or do something with that third sentence?
Well, we might focus the question, sort of the substantive issue prior to the sentence is, do we care about harms? Do we care about benefits? Do we care about both of them? Just starting there. What are the criteria by which we regulate?
Mr. Lund has a comment, but is on mute.
I guess I have more of a question. Do we need to have this battle in the statement of purpose, or isn't it elegantly stated if it ends with California, period? And then we flesh out the actual regulatory, criteria in another sort of element of our project.
So that's a good question. Mr. Gupta has a comment.
Yeah, I was just going to say, I mean, certainly the balancing test could maybe go under the application process, right? But I do think that it's important to point out that the purpose of the sandbox is to identify regulatory barriers.
So that's helpful. Ms. Alkenbrock.
I think, and this is something that we discussed in our subcommittee meeting, was I think we can all agree that the people in the state of California deserve and are entitled to quality legal services from competent providers. And, we can get hung up on how we're going to define those terms, whether we're going to go to, and I think this is kind of where, and it's alluded to in our in the memo that was provided by the co-chairs, but that's an important part that we want to make sure that the people are receiving from anybody that's going to be playing in the sandbox. And I think that could be a very important part of the purpose statement.
Do you think that it is inadequately captured by the second sentence's focus on competent legal services or affordable and competent legal services? Because I agree with you, that's an important phrase, but I'm not sure if we're paying insufficient attention to it. Ms. Alkenbrock, you're on mute. I'm not sure if you tried to answer my question or if you're thinking about it, but.
Sorry, I'm thinking about it.
Okay, while you think about it, I'm going to suggest that we circle back to the first sentence with the following in mind. It sounds as though there are a fair number of people who think we should, well, no, let me ask this. Is there any disagreement with the idea that we would take the balancing of benefits and harms out of our statement of purpose and put it somewhere else specific to applicants? And Ms. Alkenbrock, do you have a comment on that? Or, oh, you're on mute.
I'm very sorry. I need to remember to lower my hand.
Okay. So if we're going to take, assuming for a moment that we're going to take the benefits and harms out of our statement of purpose, but leave what's currently there, the sandbox is intended to identify objectively regulatory barriers that prohibit expanding such access. We could just, if we can just undo what you just did, that would be helpful. It would be, we could just end the sentence there, but I think we have to figure out a little bit what the first sentence is going to say about changes to the laws and rules, because while I think Ms. Baldwin's point was well taken, that that's kind of an uninspiring way to start, I do think we need to capture in our statement of purpose that we are gathering information so as to inform a decision about changing the laws and rules governing the practice of legal services. So I guess what we have here is on the screen is we have an amended first sentence. We have a Toby alternate. There was a and I guess Ms. Baldwin's proposal is not written here.
Ms. Baldwin's proposal is the first sentence that is there now.
I see. Thank you.
I'm happy to substitute Toby's.
Okay, it's a little garbled as it's captured here, I think.
Yeah.
The purpose of the sandbox is to encourage innovation. It would be in the provision of legal services by, now do we have to say by experimenting with modifying the laws and rules considering the practice of law? But my only concern is we're not actually modifying the laws and rules now. We're experimenting with that in Ms. Baldwin had a nice phrase about in a controlled environment or something like that. Closely monitored environment. And I think the original proposal put some emphasis on monitoring that was helpful. Let me ask Mr. Green and Professor Sandifer, is it helpful for us to continue this process, or do you feel like it would be best if we leave you now to take the various suggestions and come back with a revised model?
If the group is if the group is comfortable with a slightly less garbled Toby alternative first sentence, the second sentence that we have, and ending the third sentence at access, then I think the task for our group is to develop the wide open and the targeted manifestations of that general description. So are we okay with those three sentences?
I think that works for me. I mean, we obviously this will get changed to more approximately capture the two distinct positions, but you know, as a basic starting point, I think this is fine.
But the statement of purpose won't actually capture the two. It will paper over the division, right?
Oh, well, point well taken. This could work for both.
I think that's the goal.
Okay.
And the first sentence needs some work still, but we're getting close in the sense that we might be close to finish on the second and the third. Mr. Moore, you have your hand raised, please.
Yeah, I apologize. I had something to say, but since we were moving on from what I was going to comment on, it's not worth talking about right now. So I'll take my hand down. Thank you.
Okay, sorry.
Yeah, my apologies.
Then would the scope subcommittee like to walk us through some of the issues in the remainder of your report in the remainder of our meeting time?
Sure. So I think that the next one may generate more discussion. So that's the question under the first subheading under public protection objectives. So we as a group were able to come to, I think, consensus on the idea that the services being offered by Sandbox candidates should represent competent legal services. We did not come to a final conclusion. I think there might have been some lean on this in one direction versus another, but I don't think we came to a final conclusion on whether, when we use the term competent legal services, whether or not that's congruent or completely congruent with the duty of competency that lawyers have, and that's best represented by Rule 1.1. So we still need to have, I think, a significant discussion about what does competence mean in this context. The second sentence here is that we believe that some of the candidates may well provide, specific subparts of what is generally seen as a complete lawyer service package. So if you're doing somebody's divorce, you or your paralegal handle, for example, the financial statements that are involved in those things. Whereas we may well see unbundling as we progress with this process. There might be somebody that wants to offer a form completion service. They help people with that. So the idea is that that would be an appropriate offering, but if it was a subpart, if it was a piece as opposed to the whole traditional service, that would be subject to what we describe in the second piece as the duty of transparency, and that is disclose what the limits of what it is you're talking about. And then in the transparency discussion, that incorporates some of the conversations we had earlier with the Utah folks in terms of trap doors and exit ramps if the service was beyond that. Your problem was beyond the service being offered, that you have to disclose to people what the extent of and the scope of the usefulness of your service. But the first question is, what does competent mean? In the broad brush of that discussion was competence has a specific, there's some ambiguity, but if you're doing somebody's will, there is a certain minimum level of quality you're supposed to provide. And that's generally understood, it's tested, there's case law. The other side of the conversation was that, well, gee, if you make it cross-reference to lawyer standards, then that may dissuade people from participating as innovators, that they might want a separate standard, whatever that might be. So that's the broad brush spectrum of things. Becky, did I get most of that anyway?
Absolutely. I think the only thing I would add from the competency conversation is that part of it was framed as what's the baseline from which we want to see improvement. So is it that we want to have 1,000 flowers bloom that are substantively similar to attorneys, but offering what attorneys offer in a different way? Or do we want the flowers to be different than the vast empty field of dirt, which is where most people are now, right? So is it good enough that is the idea that the service is better than nothing? Or is the idea that the service is as good as what the people over on the other side of the fence are getting, I think?
Judge Chang has a question before we go on.
Oh, actually, it's a comment.
Comment.
From the judicial perspective, as the person who's reading this stuff, I really, really, really would like them to be like the lawyers. Because the field of dirt stuff, it's a mess.
Yeah, I must admit, I fell on Judge Chang's perspective on this. I mean, if the option is nothing, I can give you nothing plus a little bit and I'm good to go. I just don't think we could ever go to the legislature and say that's what we came up with. I mean, it's just inconceivable. But it is the case that there was a major debate, and it's a fair set of questions that we need to sort of run through.
Mr. Rothschild.
Yeah, I just would echo that and say, the experience of my clients who are potential clients, people who go to what are now unlicensed, unregulated paralegals, they're getting more than nothing, but it may in fact be worth less than nothing. So that,
Mr. Lund.
Yeah, I appreciate the concern for competency, and I think it's a very real point. I would just simply respectfully suggest that we let the market determine that, as opposed to writing that into a rule at the front end. And I also think that you're biting off a huge regulatory burden to try to verify whether a particular service that a particular applicant's proposing is indeed a competent service. Are you going to, how exactly is that going to be decided before they're allowed to even participate? At some level, that's the point of letting them participate, is to see if what they're doing is indeed helpful and not causing, detriment to people.
Let me respond directly to that point, which is a really well taken one. I don't know that we're saying necessarily that the sandbox is going to determine up front whether or not lawyer competent services are going to be provided or not. I think we're talking about what's the standard that the service provider is going to hold